Your attorney announced that the state's going to dismiss the 973 case in return for a plea to the 1722 case as charged for failure to register, and that'll be adjudication of guilt, 6 months community control with a GPS monitor, as well as court costs. Is that just 515? Okay, I think it's 515. They're going to double check that, and then $150 to the PD fee. And you can pay that during the course of your probation or your community control. Is that what you want to do today?
Yes, sir.
Okay. Have you gone over this plea and sentencing agreement with your lawyer?
Sir?
Did you understand and sign it?
Sir?
You satisfied with your lawyer's advice?
Absolutely.
Okay. And are you under the influence of any alcohol, drugs, or controlled substances?
No.
Any mental health issues that you're currently suffering from? Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for your plea?
No.
All right, and do you understand by entering a plea, there won't be a trial of any kind?
Right.
And you're giving up your trial rights, which are on page 2 of that agreement that you signed?
Correct.
And do you understand you're waiving all potential defenses that you may have?
Yes.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation? Okay. And what is your plea as to the failure to register in 25 CF 1722?
No contest.
I'll accept your no contest plea. This is a downward departure based on?
Uncoerced plea agreement, Your Honor. And, Your Honor, we would also announce the null clause in 25973, based on additional evidence and receipts that we were provided, we cannot prove those charges.
All right, so in the 1722 case, the one that's left, it's adjudication of guilt, 6 months on community control, GPS monitor, $1 per day, 515 in court costs. Oh, 817? Okay, 817 in court costs, $150 PD fee, you'll be adjudicated guilty, so that's a felony conviction. And I believe that's it. All right, as announced, this is a downward departure based on uncoerced plea bargain. I need you to speak with probation and then be fingerprinted, and then you've got 30 days to appeal the judgment and sentence. Sir?
That's GPS prior to release?
Prior to release, so hopefully they can get the paperwork in today, but it may end up being tomorrow, just so you know.
Thank you, Judge.
Thank you.
Yeah, I can go ahead and do Gavin. Yeah, Zaria Bell, that's the one.
Oh, Zaria.
In fact, no, I scheduled a motion to dismiss on the call. Came back, no drugs identified. Oh, wait a minute, sorry. No, I'm thinking of, what's your name, sir?
This is Lewis, this is,
All right, I knew he looked familiar, but he wasn't Mr. Bell. I had him before, Judge.
okay.
Your Honor, this is Derek Lewis, Jr., before the court on 23 CF 2797. He is ready at this time to enter a plea to the court on burglary of a dwelling while armed with a dangerous weapon, aggravated battery with a deadly weapon, and 3 counts of violation of an injunction.
When you say plea to the court, do you mean without an agreement?
That's correct, Your Honor.
Gotcha.
If I may approach?
Does he understand the sentencing wouldn't be today?
That's correct, Your Honor. I did explain that to him.
Just so I can learn enough about you, Mr. Lewis, to make a good decision on your sentence.
Yes, sir.
If I may approach?
Leonie?
No, no, no.
Oh, I thought you were stopping her, you were just.
No, I'm sorry, no, no.
Come on. Thank you, Ms. Rivers. I just wanted to make sure I was clear about that. All right, Mr. Lewis, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
And you're here, Mr. Lewis, in 23 CF 2797, where you're charged with burglary of a dwelling while armed with a dangerous weapon, which is a life felony, which means you can get life in prison for that. Aggravated battery with a deadly weapon, second-degree felony, which is a maximum penalty of 15 years in state prison. And then 3 counts of violation of injunction, each of which are first-degree misdemeanors and punishable by up to a year in county jail. Do you understand all that? All right. I have it's a plea and sentencing agreement, but there isn't an agreement between you and the state. Is that correct?
Yes.
All right, so you're pleading what they sometimes refer to as straight up to the court.
Yes.
So do you understand that means I can give you any sentence all the way up to the maximum, which includes life in prison for this case? You understand? I'm not trying to indicate what I might do. I don't know anything about your case or your history other than what I've just been handed. I just want to make sure you understand the maximum penalty is life in prison.
Yes, sir.
Okay, I'm also looking at a score sheet, which are your sentencing guidelines, where it shows that you score 61.5 months as a lowest permissible sentence. Do you understand that? So that means I would have to give you 61.5 months as a minimum unless you're able to convince me of a mitigating circumstance under, was it 921.0022 or 26? Which would be a reason for a downward departure. So you'd have to prove that, number one, you're eligible for it based on the fact that when you fit one of those categories, and then two, convince me that that's the right thing to do in your case. Do you understand that? Okay. I just want to make sure you understand. I'm sure Ms. Rivers has gone over this with you. I just want to make sure it's on the record that I've talked to you about it as well. All right. Is that what you want to do today? Okay. And Mr. Lewis, have you had enough time to speak with your lawyer, Ms. Rivers, about your case?
Yes, sir.
Are you satisfied with her work up to this point? Okay. And you understand the agreement that you signed, it really isn't an agreement, it's just a plea to these charges, right?
Yes, sir.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Ms. Leone, did you want to sign that? I know it's not an agreement, but
I
just,
can sign it, Your Honor. Yes.
and do you understand, Mr. Lewis, if you go forward with this plea, there won't be a trial of any kind?
Yes, sir.
And you understand that you're giving up your trial rights, which are listed on page 2 of the document that you signed?
Yes, sir.
Okay. Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Did anyone promise you anything in return for your plea?
No, sir.
Is there anything that I've done or said here today that would indicate to you something I may do as far as what your sentence is?
No, sir.
Okay, I don't intend to do that. I just want to make sure if there was something I did or said that we could address that, so I can tell you that wasn't my intent in doing it if I did. All right, and let's see here. Ms. Rivers, has the court made any decisions? I don't remember any motions to suppress or anything like that,
I didn't have the case originally, I don't believe so.
and neither did I, because it's a 2023 case.
There was never a motion to suppress.
Or anything like that as far as appellate issues? Okay.
No, Mr. Williams, I'm sorry.
Is there anything that y'all are trying to preserve for appeal and him taking this plea?
Judge, the only motion that I recall bringing was a motion to compel the DNA results, which they agreed to.
Yes.
So I don't think there's anything subject to an appeal.
All right, so just so you know, Mr. Lewis, you'd be giving, without preserving anything else for appeal, you'd be giving up your right to appeal any other issue regarding that the court may have made, including the issue of guilt or innocence. Do you understand that?
Yes, sir.
Okay. And that's part of what you've read in this document. I just want to make sure that we've talked about it. All right. Are you asking for a PSI, Ms. Rivers? I'm going to take his plea. I just want to know where we're going with it.
No, Your Honor.
All right. So, Mr. Lewis, what is your plea to the burglary of a dwelling while armed with a dangerous weapon, which, as I said, is a life felony punishable by life in prison?
No contest.
And what is your plea to the aggravated battery with a deadly weapon, a second-degree felony punishable by up to 15 years in prison?
No contest, Your Honor.
And what is your plea to the violations of injunction? There's 3 counts. Each of them are a first-degree misdemeanor and punishable by up to a year in county jail.
No contest, Your Honor.
I'm going to accept your plea as freely, voluntarily, knowingly given. When do y'all want to set that for sentencing? That's why I asked about the PSI. Obviously, we can do it a little bit faster if we're not doing the PSI, but if you want more time, we can certainly do that.
Your Honor, do we have something, I mean, we could do it next week, or we could do it after trials?
Yeah, and I need time to get the victim here, so.
Okay. What about that December 4th date? I don't think I have anything else as far as miscellaneous in November, do I?
No, we don't have anything in November and December
Because we have the
even.
2 trial weeks, and there's Thanksgiving week, and then we're in December, so. All right, why don't we put it on for December 4th? Let's put it on in the afternoon.
Yes, please.
All right, 2 o'clock for sentencing. If y'all are going to provide anything as far as letters, statements, other evidence, case law, just make sure you provide it to my office ahead of time so that I can read it before the December 4th date. Anything else?
No, Your Honor.
And we'll see you back on December 4th, Mr. Lewis, for your sentencing. I'm sure Ms. Rivers will come out and see you before that date and talk about how you're going to proceed. Thank you. You said this is Bell?
Yes, sir.
This is the one you filed that motion on yesterday, right, Mr.?
That's correct, Judge.
Yeah, he says he'll do 8 years probation. Okay. Yeah, we can do that.
Consider that.
Okay.
Judge, so I filed a motion. I've explained that to the client. He made an offer to the state today, which I pass on to the state. State's going to need a little bit of time to think about that. Can we pass it until Monday for plea or continuance?
Your continuance on Monday?
I say that, otherwise, Judge, I'd kind of push it for trial. But since they're considering a plea offer, I don't mind doing it as plea or continuance.
All right, you understand that, Mr. Bell?
Yes, sir.
Okay. All right, November 3rd, 9 o'clock, plea or continue.
Thank you, sir. Judge, this is Mr. Gabney. Trying to juggle a fair amount here. Mr. Gabney was set on the docket. He just picked up another case, though. And I think he's got a pretrial detention scheduled for tomorrow at 12:30. Can we pass this, handle it with the pretrial detention? I think the 2 cases are ultimately going to need to track together.
Okay.
And if I may, Your Honor, I know we went back and forth about where the pretrial detention was gonna be heard because he was arrested in the south end with and
Yeah,
we
I had
should be,
forgotten about that.
yeah, it should be in front of Judge Clark. It's my understanding that they will ask a continuance with Judge Clark so that in the meantime, they can transfer it here and Your Honor can hear it next Thursday.
Why can't we just ask them to bring it up here for tomorrow?
I don't, because they needed a motion to transfer division, all of that. I mean, I don't mind. I'm gonna be here anyway.
Yeah, I understand.
Judge,
Yeah, have y'all reviewed it to see if you're gonna file a pretrial detention?
They filed it already, Your
They
Honor.
filed it
Yeah,
already,
yeah,
okay.
yeah.
Mr. Williams?
Judge, do you want to pass it then until, till Monday? Just see what happens there? Or what I can do is just go ahead and move to continue it until the
Well,
22nd.
the problem is, he was arrested on the 23rd. They've filed, but so if I don't get it done within the timeframe,
Oh, I meant this case that's currently
this
assigned
case,
to you.
okay.
Yes, sir. But I would agree with you. Somebody's got to do the pretrial detention motion either up here or down
I
there.
guess the way I see it is this way, and it's, maybe this is kind of going too far behind the curtain, but one of the reasons that we decided that every judge would do their own pretrial detention hearings is so there's not a pretrial detention hearing by one judge and then another bond hearing by another judge. So we're not having basically three different judges potentially look at the same case, first appearance, pretrial detention, and a bond hearing. So if it goes down south, and they do it down south, then there could be he could move for a bond hearing in front of his assigned judge, which would then be me.
Yes, sir.
The public defender, Mr. Gates, in the South End, sent an email to me and the prosecutor, Mr. Sprouse, saying that he was gonna ask for a continuance himself, so
Okay.
whatever the court tells me to do, I will.
Well, I'm not telling you to do anything. I just want to make sure, that we're being as efficient as we can be, to not have him go down there just to have nothing happen, then come back up here, then I'll make the decision anyway. Why put it off for a week?
Yes, and one more thing, Your Honor, also,
But no, I can't take a case away from another judge. I can,
Right.
they can give me a new case because of a transfer, but I can't just take it away from them. So I don't have the power to do what I think would be the right thing in this particular situation, but if y'all file a motion, I can do it that
yes,
way.
I wanted to only mention that his bond was revoked in this present case, so you,
It wouldn't change anything.
Yeah, I
anyway.
learned that happened yesterday, or I learned today that happened yesterday.
so that's all.
All right, so we're probably talking about somewhat of a moot point until
Yes,
there's
sir.
potentially a motion to reinstate bond. So, all right.
Judge, for this one, do you want me to just go ahead and
Let's just-
set it for the 22nd then? I will not be doing the pretrial detentions next week.
Okay.
I'm going to have to ask one of my fellow attorneys to cover that and for me. It would ordinarily be my turn.
All right, so you want to just
Let's just
December
go ahead and
23rd?
continue it, Judge, set it for the 22nd.
It'll be the 23rd because he's in
Or
custody.
23rd.
All right, December 23rd at 9 o'clock for the next pretrial conference. Mr. Gabney, I'm not sure if you'll end up back in front of me tomorrow or down south in front of, did you say it was Judge Clark? For a pretrial detention here, but it sounds like it's going to get continued to come back to me next week anyway.
Sir.
All right, thank you, Judge.
Because even if they don't seek pretrial detention, which they are, or if the court determined that they didn't meet their burden, you're still being held on the bond revocation in my case. So it's probably better we just do everything in front of one judge. All right, thank you, Mr. Gabney. We'll see you possibly tomorrow.
And then back to Ms. Rivers with Shane Morrow.
Well, actually, I got to go backwards because it's,
Your Honor, this is Shane Morrow before the court on 21 CF 2674, 21 CF 2998, 22 CF 273. We did have depositions. The officer that we deposed did say that there was body camera, that he was going to send it to us, and I believe it was
What
sent.
case is that in?
I believe it was sent. I'll have to follow
I
up and make sure it was.
Believe it was sent, but I haven't had the opportunity to review it, if it was, and to be able to show it to Mr. Morrow. And it would be the two cases, Your Honor, are linked. They're basically the same. So that would be the 21 CF 2674 and the 22 CF 273. The other one is a VOP.
So the 21 CF 2998 is a VOP?
Yes, Your Honor. What it was originally over in Santa Rosa County. In order for us to take the jurisdiction over here at the time, we had to transfer it over and give it a case number over here. It was being handled altogether by the agreement of the councils.
All right, so what do you want to do with it, Ms. Rivers?
So, Your Honor, I am asking to continue it, so I have an opportunity to review it and to show it to Mr. Morrow.
All right, you understand that, Mr. Morrow?
Sir?
You understand that?
Oh, yes, sir.
Okay, just want to make sure you didn't have any other questions. All right, then we'll see you back on December 23rd at 9 o'clock for your next pretrial. Obviously, if something comes up earlier, they can set it for hearings before that. All right, thank you.
Okay.
Mr. Osborne?
Your Honor, this is Kenneth Osborne, 16 CF 1542. We have a motion to suppress set for tomorrow.
In the afternoon?
Yes, Your Honor.
It is, Your Honor.
After that, Your Honor, I anticipate another possible issue that could arise. So
Can Mr. Osborne hear us okay? You can hear us okay, Mr. Osborne?
Yes, sir.
Okay, just want to make sure.
Thank you.
So based on that, I would anticipate us going to trial in January.
What is the suppression issue? I don't think I've seen the motion.
It has to do with the search warrant, Your Honor. You're not feeling good? Do the hearing tomorrow? Your Honor, Mr. Osborne is looking a little yellow. He is saying he is not feeling well. He's asking if we would continue the hearing tomorrow.
It's without objection, Your Honor. I believe we have a pretty busy day. and It is Mr.
I was just looking at that. I think one of our other potentially longer hearings for the tomorrow afternoon's getting postponed again, Mr. Williams.
That's what it looks like, Judge. I need to talk with Mr. Hinesley about it, but it's likely I'm going to continue that one. The state also is.
Oh, I was talking about
It was
Norris.
Norris.
I was talking about Norris.
Oh,
We've also got Hinesley set in the morning for sentencing, and I don't think either one of us are really prepared.
yeah, Your Honor, I saw it on the morning docket, the Ainsley sentencing, and I was surprised because that may take a little bit. It's not an agreed upon sentence, obviously.
He in custody already?
He is, Judge.
Yeah,
He was
it was the
remanded
trial
after the
case we
trial.
had. Sex battery case.
Yeah, Your Honor, he had been in the hospital, and he's still a little.
All right, Mr. Osborne, I mean, do you want to see if you're feeling better tomorrow, or you just want to go ahead and push it out to a new date today?
Your Honor, he's asking to just go ahead and continue it for now, till he gathers up some more strength.
All right, that's fine. I just want to make sure you understand if you're asking for a continuance, it may be another potentially month or two before we can get it back on the docket for this type of hearing.
Your Honor, he's indicated that he's fine with that.
Okay.
So, Your Honor, can we put put on the regular docket to 12:23?
Yes, 12:23, 9 o'clock will be your next pretrial conference, Mr. Osborne. Are you canceling tomorrow's hearing then?
Yes, Your Honor.
Okay.
Get to
If
feeling
just
better, okay?
for file purposes, if you could file a notice of
Yes, Your
cancellation,
Honor.
even though we all know what's going on today.
Okay.
Not to get too off topic, but ultimately, if this case has now been continued and Norris is being continued tomorrow afternoon, do y'all want to see if we just bump Hinesley to the afternoon? I don't know if you all have witnesses coming in or anything like that, but I'll be here all day. I'm just trying to make it easier on everybody else.
I do have, obviously, victim and witness.
But ultimately, if you talk to them and they want to push it in the afternoon, I just don't want everyone to have to sit around for too long or have 50 people wait through a very long hearing.
Yes, yes.
Has there been a PSI or anything on that?
I haven't seen one, Judge.
Did we ask for one?
I don't recall. If he's a first-time felony offender, normally I would have.
It's not the first time that I know.
But I know that.
Why don't y'all discuss it while we go through some cases, but I just wanted to make sure that if we're going to be ready for it tomorrow now that we're talking about it.
Yes, sir.
All right, who do you have, Ms. Rivers?
Your Honor, this is Peyton Pierce. Your Honor, he's in the process of retaining Mr. Powell, and
Which
Bo
one?
Powell.
Bo Powell, okay.
And Mr. Powell asked me if I would go ahead and request a continuance to the 12/23 court date, or would it be 12/22 for private attorneys?
No, because he's in custody, it's all on the 23rd.
Okay, so he's requesting 12/23, Your Honor.
Okay. Is that what you want to do today, Mr. Pierce? Have you retained Mr. Powell yet?
Yes, sir, I have.
Okay. All right, then we'll put you on our next pretrial date, which would be December 23rd at 9 o'clock.
Thank you.
Did y'all do depots recently or no? I know y'all were talking about it last time. No big deal.
Your Honor, this is Jeffrey Pope, 25 CF 1587. Your Honor, we've gone over his discovery together. We need to go over videos and decide how to proceed, so we're going to request a continuance. This is his first time up. So we're requesting 12/23.
What you want to do, Mr. Pope? You want to continue the case so you can go over discovery with your lawyer?
Yeah,
What does he want to do?
he wants to know if you want to.
You want to go over discovery with your lawyer? All right, we'll see you back on December 23rd at 9 o'clock, Mr. Pope.
You ready?
What's your sign?
Your Honor, this is Dwayne Robinson before the court on 24 CF 59. We've reached an agreement in this matter, if I may approach.
Thank you. All right, Mr. Robinson, can you raise your hand, right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Dwayne Andrew Robinson Jr., May 16, 1998.
All right. And Mr. Robinson, you're here in 24 CF 59, where you're currently charged with fleeing and eluding with lights and siren, which is a second-degree felony punishable by up to 15 years in state prison. Resisting without violence, first-degree misdemeanor, max a year county jail. And false imprisonment, third-degree felony punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right. I've been given a plea and sentencing agreement between you and the state that calls for you to plea no contest to count 1, which is the fleeing and eluding. It'd be a sentence of 11 months, 29 days in Okaloosa County Jail, credit for all times previously served, a 1-year driver's license suspension, $415 in court costs, $100 cost of prosecution, $100 PD fee, and $50 application. And then the state, in return for you taking that plea, will dismiss counts 2 and 3. Is that what you want to do today?
Yes, sir.
Okay. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign the plea agreement?
Yes, sir.
And are you satisfied with your attorney's advice and representation in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering the plea, there won't be a trial of any kind?
Yes, sir.
And do you understand you're waiving all potential defenses that you may have? You understand you're giving up your trial rights, which are on page 1, going into page 2 of the agreement you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And it's a felony adjudication, so it's a conviction of a felony. You understand that?
Yes, sir.
Okay. And what is your plea to the fleeing to elude second-degree felony?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty as to count 1. State have an announcement on counts 2 and 3. Ms. Leone?
The state dismisses counts 2 and 3.
All right, thank you. On count 1, it's going to be 11 months, 29 days in the Okaloosa County Jail with credit for time served, $415 in court costs, $100 cost prosecution, $100 PD fee, $50 application fee, and a 1-year driver's license suspension. This is a guideline sentence. He scored 22.5 points. So, Mr. Robinson, I'll just need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence.
Okay, so,
You can come up and be fingerprinted, yes, sir.
Your Honor, this is Denisha Ross, 25 CF 1363. If I may approach with the state.
Yes. Ms. Ross. We're waiting on that report. We're going to bring you back on Monday. We think
Back
we'll
Home
have it
Bakery
by
Cafe
then,
is
hopefully.
2 blocks from the courthouse on
So that's
Crestview
November
Historic
3rd
Main Street. We serve
at,
handmade
9
pastries,
o'clock. We'll see you back
espresso,
then.
and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m. Serving
He doesn't want.
Find out. Guess I will have to make a phone call after all.
What do y'all want to do then?
The November, what is it,
Why
November
why don't we,
6th?
if you don't mind, maybe keep it on for Monday. Make the phone call, and that way we can see where we might, or when we might get it, the report, and set it based on that.
Yes, Your Honor.
So it sounds like not much is going to happen on Monday, Ms. Ross, but I want to make sure that we're pushing it as fast as possible based on what you just told us that we weren't aware of.
Thank you.
All right, thank you, Ms. Ross. We'll see you on Monday.
Your Honor, this is Lawrence Rudd before the court on 24 CF 2754, 25 CF 1723. I just recently showed Mr. Rudd the videos on the 25 CF 1723. We are going to set depositions. And so in this case, I'm going to request continuance to the 12/23.
All right, Mr. Rudd, we'll see you back December 23rd, 9 o'clock.
Your Honor, if I may have a moment with Mr. Saber? So are you,
You see my driver's license number?
Mm-hmm.
It's not the same.
Your Honor, in speaking with Mr. Saber, he's indicated he is not going to accept the state's offer.
What's the offer? I'm
Ma'am?
just curious. Prison without the order. That's no prison for me.
Your Honor, Ms. Leone, if you could announce the offer by the state.
I'm just curious what the state says. I ain't worried about the state says.
1 second, let me retrieve it.
Oh, my tummy.
We have conducted depositions in this matter.
Do you watch the video?
The offer that was extended by Mr. Sheik is for 60 months DOC.
No.
Yeah.
Tell Shania to watch that video. That's the ownership.
So, Your Honor, we would be announcing ready for trial at this time.
They going to be ready for trial?
Yes, Your Honor. In 25 CF 1769.
Or does he have more than one?
Oh, no, that one we haven't done depositions on yet.
That's the one we're ready for.
I don't even see that one on my docket.
No, that one we're not ready on yet, Your Honor. So if that's the
Ain't got
case,
the
then,
paperwork on that one yet.
yeah, we're,
Ain't got the
that
video on
one,
that one.
that one's, we just got.
This is the other one.
He and I haven't even been over discovery on that one yet.
Trying to pull it up now, but the new system's a
Ain't
little
got the
bit.
paperwork on it yet. Order's covered.
Yeah.
Ain't nothing on it.
Yeah, that one has arraignment tomorrow.
Yes.
So I don't think we can set that one for trial yet. They're going to be ready on the 866
I'm
case.
checking, Your Honor, because I don't know about FTLE or not. Do you know, Ms. Rivers, if we got the FTLE here? I don't see it. But
So tomorrow we come back. What do you think?
we don't have the FTLE, Your Honor.
You don't have it,
so,
no.
no.
What's the state asking for?
I'm asking to continue, Your Honor.
There was a defense continuance on June 24th. Meet again on August 25th to today's date.
I am willing, though, Your Honor, to make sorry to interrupt,
Go ahead.
an amended offer for both cases. Okay, on the first case, the possession of controlled substance only, he scores 31.3 months. I'd be willing to offer 36 months for both cases, the burglary and this possession one.
I want to talk, since we're already set for tomorrow, do y'all want to talk about it tomorrow?
That's
Or
fine.
give you a chance to talk to your client, Ms. Rivers, and see if he wants to take it tomorrow. Otherwise, we can always set it for
No.
trial from there. No.
You need to watch the video.
All right, Ms. Leoni, what's the state's position? You're asking for a continuance
Yes, Your
of the
Honor.
case? Ms. Rivers?
No objection.
Say again?
No objection.
All right, so we want to put it on December 23rd?
Yes, Your Honor.
December 23rd, next pretrial. We'll see you tomorrow, Mr. Saber, for your
Bond hearing.
arraignment on the new case and the bond hearing on this case.
Yes, Your Honor.
I just looked at the bond motion. He was out in the meantime, right?
Yes, Your Honor.
Okay, because it says he was incarcerated since April 28th, which,
No, it was,
I know. I know he was released at some point, and then they got the new case, and that's why he's in, and his bond was revoked at first appearance.
Just bond.
Sorry, Your Honor.
Tell the state.
Your Honor, this is Melinda Settle before the court on 25 CF 1466, 25 CF 1745. Your Honor, we have a hearing set on your next available miscellaneous date.
You want it set, or already is set?
I'm sorry?
It is set, or you want it to be set?
It's already set, Your Honor. We got the report on her yesterday, and my assistant went ahead on your next available miscellaneous date and set the hearing.
Competency says November 6th, 9 a.m. So next week. What do we want to do with the case other than that?
Your Honor, we would just,
I don't think I've seen a report. Oh, wait. Is this
it should be attached, Your Honor.
I see. Well, no, I see a reciprocal discovery exhibit, but I don't see anything as part of that. So I don't have an actual report, so if you can get that to me before next week.
Yes, Your Honor.
All right, but as far as the pretrial date, do we want to keep it on for anything next week, or is it the 23rd?
I would leave it for next week.
Well, I have to give it another date. Remember Monday, we had a couple of cases that just kind of fell off the docket because I didn't give them a pretrial date, and I want to make sure we don't do that.
12/23 then, Your Honor.
All right. All right, so Ms. Settle, we'll see you next week on Thursday, the 6th, and then your next pretrial will be 12/23.
And then what happens?
We won't know until we discuss it on Thursday.
Okay.
Okay?
Yeah, because I was asking. So in 2 weeks?
No, 1 week.
1 week? 1
Yes.
week, okay.
Ms. Rivers, I know we talked about him briefly, but Ken Sean Scott, who's in DOC, what are we doing with his case? Just
Your Honor, previously, the state was waiting for the,
23 CF 936, sorry, go ahead.
previously, Your Honor, the state was waiting on the autopsy report to determine whether they were going to go forward on the case.
We don't have that yet, you know, it doesn't come through.
A 23 case?
The autopsy hasn't come through, the victim passed away maybe a few months ago.
Oh, okay.
He was originally charged with ag battery on the
I see
victim.
that. Yeah, I'm sorry, I just didn't,
No, you're fine.
I wasn't tracking, but that
Yes,
makes
sir.
sense. All right. All right, this is Ronald Schaffner?
Yes, Your
Okay.
Honor. He's before the court on 25 CF 1744. He also has another case that we'd like to resolve today, and that's 25 CF 2006.
This is the guy I had to let out, got a new chart. All right, Mr. Schaffner, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Ronald Ben Schaffner Jr., January the 12th, 1968.
All right, Mr. Schaffner, you're here on two cases, 25 CF 1744, which was the case you were originally on the docket for, but then there's a brand-new case that you're asking to resolve today, which is 25 CF 2006. The first case is battery on a person over 65, third-degree felony. The new case is possession of controlled substance, third-degree felony, possession of drug paraphernalia, and resisting without. Both of those are first-degree misdemeanors. Do you understand that?
Yes, sir.
Okay. I've been handed a plea and sentencing agreement that calls for you to plea as charged on the battery over 65 in the 1744 case. Be 3 years of probation, waive costs of supervision, $967 in court costs, $100 PD fee, $100 cost of prosecution, $50 application fee, 50 hours community service, or you can buy them out by donating to a domestic violence organization as part of the agreement. Complete batter's intervention and a mental health evaluation and a recommended treatment, or you can comply with the Emerald Coast Life Center. Write a letter of apology to the victim in the case, who's your mother, correct?
Yes, sir.
And then no contact with her unless she submits a notarized statement to probation. So that means until that happens, or if it happens, you can't have any contact with her. You understand
Okay,
that?
Your Honor.
And you understand that if you do, you could be arrested and your probation violated.
I do.
Okay. And then in 25 CF 2006, on the felony count, which is the controlled substance, it'd be 3 years of concurrent probation, substance abuse evaluation, and counseling, or again, comply with ECLC. And then your cost, $515, $100 cost of prosecution, $100 PD, waive costs of supervision, and 50 hours of community service. Just says on the misdemeanor accounts, and there's nothing there, is it time served? Okay, then time served on the misdemeanors. Question?
Question on the sentence, is it 100 hours total or just 50 hours?
Just 50.
Okay.
Oh, no, I'm sorry. So it's 50, there's 50, and then there's another 50 written in, and handwritten in. So is it 100?
It's 50 per case.
50 per case, so you're right, it is 100, sir. All right, is that what you want to do today, Mr. Schaffner?
Yes, sir, I do.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Pardon me?
Did you go over this plea and sentencing agreement with your lawyer?
Yes, she did.
Okay, did you understand it?
Yes, sir, I did.
All right, did you sign the agreement?
I did.
Are you satisfied with your lawyer's help in this case?
Very.
Okay, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I am not.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that by entering a plea, there won't be a trial of any kind?
I do.
Do you understand that you'd be giving up your trial rights, which are on page 2 of that agreement that you signed?
Yes, sir, I do.
And do you understand that you'd be giving up all potential defenses that you may have?
I do.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, so in the 25 CF 1744, what is your plea to the battery on a person over 65?
No contest.
All right. And on 25 CF 2006, what is your plea as to the possession of controlled substance, possession of drug paraphernalia, and resisting without violence?
No contest.
All right, I'm going to accept your 2 no contest pleas as freely, voluntarily, knowingly given. On 25 CF 1744, 3 years probation, adjudication of guilt, waive cost of supervision, $967 court cost, $100 PD fee, $100 cost of prosecution, $50 application fee, 50 hours of community service, or you may buy them out by donating the statutory amount to a domestic violence organization, complete the batter's intervention program, and either do a mental health evaluation and recommended treatment or comply with the ECLC. Write a letter of apology to the victim, your mother. Do not have any contact with her unless she submits a notarized statement to probation. On the 25 CF 2006, adjudication of guilt for each count. On the misdemeanor counts, it's just time served. On the felony count, 3 years concurrent probation, substance abuse evaluation and counseling, or comply with ECLC, 515 court costs, $100 cost prosecution, $100 PD fee, waive cost of supervision, and there'll be an additional 50 hours of community service for a total of 100. Do you understand all that, Mr. Schaffner?
Sir, Your Honor, I do.
Okay, and this is a guideline sentence as you scored 32.3 points. Mr. Schaffner, I need you to talk to probation, who's sitting behind you, then you'll need to be fingerprinted, and then you have 30 days to appeal the judgment and sentence.
Thank you, Your Honor.
Thank you, sir. Have a good day.
Tanner Phelps.
I'm all right. How about you?
Okay.
Your Honor, this is Terrence Schaffner before the court on 25 CF 1003, 25 CF 1432. Your Honor, we've taken depositions on 25 CF 1003. We're getting ready to take depositions on 25 CF 1432. And we received a request to drop charges that would, so we're going to talk to the state on whether they're going to proceed or not. At this point, we're going to request a continuance to 12/23. So, Your Honor, if we could continue this to 12/23.
All right, 12/23. I was just waiting to see if y'all changed your minds. All right, December 23rd, Mr. Schaffner, Mr. Terrence Schaffner. I know I got the other Schaffner up here as well. Obviously, if something changes and they want to bring it in for an earlier resolution, they can do that.
Does that happen sometimes, or what's the odds on that?
I can't tell you the odds.
The victim's already dropped the charges.
Well, I understand I think this is the third time I've explained this today, but you aren't here for any of them, Mr. Schaffner. But when an alleged victim says, I don't want to go forward with the case, I don't want to prosecute, the state can still do that because this is the state of Florida versus Terrence Schaffner, not the alleged victim versus Terrence Schaffner. So now, a lot of times they don't, sometimes they do, but I can't give you the odds because I don't really know anything about your case other than what you're charged with at this point.
I appreciate your time. Thank you.
No problem, Mr. Schaffner. We'll see you back on the 23rd of December or sooner if they get something worked out. All right, have a good day. Skipping people?
Hello, Mr. Strickland. How are you? Your Honor, this is James Strickland, 25 CF 864. Do you want to plead, trial, or continue?
Go ahead, go ahead.
You'd like to know if you can do 6 months county jail.
What was the thing you said? Let me pull it up. I see
So
how big.
the original, the offer was 1129 ECLC. But he wants to do 6 months, and I guess Dana's worked out,
That's it?
6 months at Okaloosa County Jail. I guess Dana's worked out someplace he can be at on the outside.
Does it score? Yeah, it's an animal case.
Oh. No, I can't do that. No.
Right. No.
You would like to put it on for next week and have you ask principal?
I'm not agreeing with that because of the animal involved.
No, you get credit for everything you've done.
To figure out, because people look at this and they're like,
All right, Ms. Rivers, do y'all want to pass it, or we've got a lot of cases to get through still? I'm fine with you bringing them back up if you want to talk to them while Mr. Williams or Mr. Russell are doing their cases, but
Put it on for tomorrow?
we put it on for tomorrow.
Or can we put this on for tomorrow?
what are we potentially going to do tomorrow? I just want to know where to put it, and
For him to make up his mind as to whether he wants to plea or continue or go to trial.
okay, well, that doesn't really narrow it down. So, I mean, I can give you some extra time and have you come back tomorrow, which is not normally how we do things, Mr. Strickland, but, tomorrow we'd have to have an answer. Do you want to go to trial? Do you want to take a plea, or do you want to continue for 2 months?
I'm gonna plea and pray on it because it's I'm not understanding why I'm being charged in the first place. I'm just gonna plea on it and pray to God about it because it's a whole situation of me being innocent and
Well, that's what trials are for, Mr. Strickland.
still like the reason, Your Honor, I'm having the iffies about going to trial is because
Don't talk about the facts of the case.
yes, sir.
It's just, the prosecutor's here, everything's recorded, anything you say can be used against you. But you're certainly have a right to a jury trial if that's what you want to do
How long would that take, sir?
in a couple of weeks. Unless there's some reason you don't think you can go forward with it yet, Ms. Rivers, I don't know. I thought you said the depositions were done last time, I think.
Yes, they've been done.
I'd like to take it to trial.
State going to be ready for trial?
We'll get ready, Your Honor.
All right, so this is James Strickland, 25 CF 864. The case for trial. We'll come back on Monday, the 3rd, just to see if there's anything else we need to address, and then jury review will be on the 7th, and that's when we'll figure out. I've got 2 trial weeks as to which one we're going to put you on. All right, thank
For the
you.
record, Your Honor, the misdemeanor offer that was in place is obviously revoked.
Okay, do you understand that, Mr. Strickland? Apparently there was an offer to let you plead to a misdemeanor. They're revoking that offer at this time.
Do you have Stevenson on yours?
Stevenson is out of jail, I'm sorry. These folks have asked to be received.
Which Stevenson?
Travis?
I thought he was in DOC I've got on my docket.
Oh, Travis. Oh, yes, but how could he be out of jail?
He's out of
He's
the,
outside of the Okaloosa County Jail. So if he's in DOC, then he would be outside of Okaloosa County Jail, or if he's at home, he's outside of Okaloosa.
But the judge ordered him to stay here.
I didn't drive him.
Okay, then.
I told y'all earlier, not everyone listens to me, so.
Mhm.
They just informed me today that he was not in jail.
All right, then. Your Honor, this is Joseph Thompson before the court on 24 CF 2424. We have one expert down. We still are waiting for the other expert to be able to conduct his examination. Ms. Basso and I have gone back and forth on his ability to be able to review the material. Even last week, we were going back and forth on this issue. So needless to say, the expert has not been out. It used to be the experts could go, they could download the material that they needed, not the porn or any kind of material like that, but the other material, to determine where it's uploaded, different things like that. And they were able to take it back, have their time to go through it. Now, the sheriff's office has changed their policy, and they're no longer able to do that. And this is a recent decision, and it's going to change.
I see two state attorney heads shaking no about that. I don't know the situation.
There's no recent change, Judge. They may have an expert that has the appropriate qualifications, can have unlimited access to the data and review it and work whatever they need to do. They cannot take anything out of the lab with them. That has always been the policy because that is a specific rule for child pornography. It's a federal rule and it's a state rule.
And again, we're not talking about taking out child pornography. We're talking about taking out the other material that's involved in the process, which has always happened. And Casey Campbell himself said it to John Sawicki when we were there, when Mr. Sawicki was here. And he indicated that it was due to a hearing and an attorney. And that a policy had changed, and he indicated that he would allow Mr. Sawicki this one last time, and after that, that Mr. Sawicki would no longer be able to do that.
That's the expert you're talking about.
No, Your Honor, I'm just using Mr. Sawicki. This is when this conversation occurred about they would no longer be able to do this because Ms. Basso has indicated that it's always occurred where they just go and they just view the material. For example, in this particular, one of the issues that has arisen in this case is who uploaded this material. So they look at, the phones, the source, that kind of thing. And I couldn't tell you much more than that because I'm not a tech person. That's why we employ the experts. And they look at that kind of information. That is material. It took Mr. Sawicki on my other case, it took him 6 hours just to download the stuff. They don't download the porn. They look at that there at the office. They've never downloaded the porn.
Judge, there's a lot of different cross going back and forth. What we suggest, and this is so we're not in the middle of it, and this is what I've said, contact the lab, set up the meeting. They know what they've done all along, and they're the ones that control the data over there. Because I know what Ms. Rivers says, I know what I'm being told, and I wasn't there. I don't know exactly who said what to whom. I do know what the policy is. That's why I say Instead of us going, hey, he said that, she said that, this is what we've always done, let the people that are actually involved with it do it. They know to give them access, and they know they have access to all the raw data. It's what the experts are qualified to go through. It's never been an issue.
Was there a time where they could copy the non-contraband data?
Your Honor, I'm not aware that they can take things with them. I do know that occasionally, once or twice, there was like a snapshot, one snapshot taken and given to a defense attorney out of a courtesy. But it was not like a whole download, nothing like that. It was just a single like image or two of a particular chat they were doing. To be able to take a clean copy of that, they cannot take a clean copy if that's what they're trying to do. Now, if there's something specific they want to get, I say let the lab work that out with them. The problem is there's a lot of these devices have child pornography or suspected child pornography in many different locations. So it's very easy for something to be missed. And then everybody's committing illegal acts. So there's never been an issue with Sawicki. He's been in there before, Mr. Sawicki. We've had other experts go in there. They've done what they needed to do. They've been able to generate reports. It's not been an issue.
I mean, the major issue is because the experts don't live around here, and so therefore they have to make special trips just to see.
That's correct, Your Honor.
And if they come up and there's 3 cases they've got to look at, it could take them days to do it.
And it's a small room, and you just have the one person sitting there, and it's the regular business hours that they're open, and all of that. And again, Casey Campbell was the one who sat there and told us that this was a
Who's that?
brand-new policy.
Who's that?
Casey Campbell, he works in the,
Your Honor, he's one of the civilian techs that's over there. He doesn't drive policy.
no, he's the one who informed us that that was the new
And
policy.
I went over there on Friday and talked to him, and it's, again, we're crossing wires with each other. That's why I don't even want to go into that here. We're crossing wires. Let the expert that needs to get in there talk to the lab folks and let them set that up. Because they're the ones that know what they need, and they're the ones that know what can be provided.
And my expert has emailed me since talking to him, and they've indicated to him that he needs a court order. And I think eventually what we're going to need to do is set a hearing. And I would follow.
Happy to have it.
Yep, I
you
think
know,
that's what we're going to need to do.
And I
This is
think
all,
this
this is
expert
all
you're
new to
talking
me.
about's a PI, actually. So we need a CV. A PI is not qualified to go through forensics unless they have a CV to show that. So again, that's a whole other issue. We can't just let people go in and look at child pornography. That's
I understand that. I don't know who the people are. I don't know what their qualifications are, so I can't make those kind of decisions if you need court intervention until everyone gives me all the information. This is the first I've ever heard of the issue. Based on that, Ms. Rivers, what do you want to do? I mean, you said you had one expert already, right?
In something that we were pursuing, yes, Your Honor.
Okay, but not this one.
No, Your Honor.
How do you want to go about it?
Your Honor, we're requesting a continuance to 12/23.
Well, I understand. I mean, the case is getting kind of old. I'm sure Mr. Thompson agrees with that.
He does.
I just need to get some progress here, and if these are issues that are going to involve more than one case, obviously, we can start talking about how this can be streamlined, especially if it involves a court order, especially if there's not an objection to the court order. I just want these things to be done a little more quickly. I understand the extreme difficulties in handling these things, because someone could inadvertently commit a very serious crime just by trying to do their job. So I understand it. I just need the details as to, what the rules are, what the policies are the policies in line with the statute, and just, we can go from there, but until that gets in front of me in a formal motion or a hearing, the first I've heard of it. All right, 12/23 at 9 o'clock. Who is Mr. Maddox? You're to the left. What's that? You gotta stay in front of it or otherwise. Are you ready, Ms. Rivers?
Yes, Your
Oh,
Honor.
I'm sorry.
That's okay. This is Warren Toledano before the court on 25 CF 392. Your Honor, we've been going back and forth on how to proceed. At this time, we are not ready to proceed. So we're going to request a continuance to 12/23.
When you say "we,"
My client.
okay, the two. I didn't know if you were going back and forth with the state.
No, Your Honor.
Okay, so what needs to be done going forward? As far as depositions, evidence issues, discovery? If I'm not hearing, why isn't it a trial then?
Your Honor, it's just discussions between the client and I
Okay.
on,
Well, I just need to know kind of where we're at with it, so I know if I'm going to start denying continuances.
I understand.
So if there's nothing left to be done,
Your Honor, we haven't done depositions yet.
well, then they'll need to be done for the next time. All right, Mr. Toledano, we'll put you on December 23rd, but I'm not just going to keep continuing the case unless the work's delayed for some reason, but there's no reason for us to keep continuing these cases. All right, we'll see you back on that date.
Carpenter, Your Honor.
This is Nolan.
Hey, Mr. Nolan.
How you doing, Mr. Maddox?
Doing all right.
I like your jacket you got now.
Thanks, man. Sign right there.
Yes, sir.
Waiving your right to your hearing, waiving your right to your trial, time served. See right there.
What's the date?
10/29/25. All right, we've reached a resolution in this matter. If I may approach?
Yes. Thank you.
Straight.
All right, Mr. Nolan, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Justin Wade Nolan, 1985, 6/12/85 is my birthday.
Okay, you can put your hand down. All right, Mr. Nolan, you're here in 25 CF 661, where you're charged with possession of a controlled substance, third-degree felony, and possession of drug paraphernalia, first-degree misdemeanor. I have a plea and sentencing agreement that calls for you to plead no contest to both counts. As charged, credit for time served, $615 court costs, $150 cost of defense, 90 days to pay those costs, or set up a payment plan.
Yes, sir.
Is that what you want to do today?
Yes, sir, Mr. Oberliesen.
All right.
Thank you.
All right. All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, I did.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
All right. Are you satisfied with your attorney's advice and representation?
Absolutely, yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return
Just
for your
what's on the
plea?
paper, sir.
Say again.
Just what's on the plea, sir.
All right, just what the plea is the
Yes,
only thing
sir.
they've promised you?
Yes, sir.
Okay. And you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
You understand you're giving up your trial rights, which are listed on page 2 of the agreement that you've signed?
Yes, sir.
And you understand if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
Okay. And what is your plea to the possession of controlled substance and the possession of drug paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Credit for time served, $615 court costs, $150 cost of defense. I'll give you 90 days to pay those costs, or set up a payment plan. It is an adjudication of guilt on both.
Thank you so very much,
All
sir.
right, you're welcome. You just need to get your fingerprints done and then 30 days to appeal. It is a
All right,
guideline
Mr.
sentence.
Make sure you make your court dates for your other cases. I know, I'm just making sure. Mayor Pro Tem Mr. Carpenter, Your Honor.
Yes.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestvview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Yes, sir.
Still won't affect me getting out today.
Yes, sir, it will. Of course, I can file a bond motion, but I'm not sure where. All right, Your Honor, due to the reasons discussed at the bench, I'm going to pursue a competency evaluation in this case, Your Honor. I'd ask for a continuance to December. I will see if I can expedite it with Dr. Zeman. I'll certainly reach out to him.
Do you understand that, Mr. Carpenter?
Because I thought this was about my plea, not about some old case, but they're trying to shed light to an old case, and
I'm sorry, they're trying to do what?
shed light to an old case, and I'm just
I don't know anything about an old case, so.
Juan Watson's Waters case.
Okay. No, I understand. I don't want to, let's not talk about that
Yeah,
here,
but-
sir, but I know you said you, I understand.
I'm just trying to get out today.
I know you are.
Signed my plea today, and
All right, Mr. Carpenter, based on what I've been told, I'm going to put it on 12/23. Doctor's going to come out to see you, and they'll give us a report.
for how long am I going to be in jail?
I mean, I don't think you agree with, would you oppose a bond hearing, some sort of?
Yes, given the situation and the fact that.
I'm going to file a
My
bond motion,
understanding
Your
is
Honor.
right now he's on a $5,000 cash or professional bond.
Correct. I'm gonna file it just because he's asked me to, Your Honor. Could we go ahead and give that a date? Of course, I haven't filed the motion, but a tentative date.
We can put it on the 6th.
Okay, that's fine.
That's next Thursday.
That's fine, Your Honor. So I'll get that filed for you today.
Hey, Your Honor, is there any way that I can get out or sign my probation today and get out?
Not based on what I've been told. No, sir. I've been, well, number one, I've witnessed some of your conversations, not with your attorney, but with the court. And I've got some concerns myself about your, whether or not you're understanding what's going on here today and what you're willing to do.
Understanding, sir.
Well, I tend to disagree based on what I've heard. I agree with your lawyer that this is something that is required to get done at this point. But we can see you next week for a bond hearing. Not going to address it then. Well,
That's why.
that's why you'll have a bond hearing to see if it's going to be lessened. But I can't give you any indication if I'm going to do that. I haven't heard anything about it. All I know is what the case is, what the charge is. Fleeing to elude is usually something I take pretty seriously. I don't know what the exact facts of it are, but it's because to me it exhibits potentially flight risk behavior. So, but get that filed, Mr. Maddox, and we can see it next Thursday.
Yes, Your Honor.
It'll be 12/23 until then.
No, but we can talk about a bond. I'll come see you again, Mr. Carpenter. Thank you, Your Honor. That's all I have. May I be excused?
Yes, sir.
All right.
Who are we back to, Ms. Rivers?
Chayton Truelove, Your Honor. He's before the court on 24 CF 60. We have a motion set for tomorrow.
Okay, what kind of motion is that?
Is asking to be able to take depositions, Your Honor.
Is it of a child or?
Yes, Your Honor.
Okay. And so I usually would have looked over those types of things before today, but because of all the other stuff we've had going on this week, I haven't got to tomorrow's docket yet. There it is. All right, so 10:30.
I can't see you today.
All right, and is this your case, Ms. Basso?
Yes,
Since you're
it is.
standing, and you're objecting to the motion?
Yes, Your Honor, they're both juveniles and CPTs have been done.
Have you filed a written response or anything?
No, sir, it's a fairly straight argument, so we
Okay.
have not.
Is there a recent statutory change to that?
The statutory change requires a court order if it's the victim and they're under 16.
Okay, we haven't dealt with it, at least not in my division
And
yet.
that's going to be my argument tomorrow
Okay.
with the statute.
What's the statute?
Give me just a second.
You know, off the top of your-
92.55, and it's subsection 6, Your Honor.
Okay, just so I can take a look at it quickly tonight before tomorrow's hearing.
Yes, sir.
All right, in the meantime, what would you like to do, Ms. Rivers?
And, Your Honor, I believe the child is now 13, so I don't believe that statute would apply.
Also, do you have a response to that? Just
Yes, Your Honor. The statute applies to any child of a sex crime under 16. It's presumptive if it's under 12. It's presumptive that the deposition will not be taken if it's under 12, but it does require a court order under 16.
We'll address it tomorrow. I'll certainly read up on it. I know it's a relatively recent change to the law that I haven't had an opportunity to deal with yet, so I'll read up on it tonight, and we'll see you tomorrow. What do you want to do with the case in the meantime? Besides,
1223, Your Honor.
all right, so Mr. Truelove, we'll see you back tomorrow for that motion, but otherwise your pretrial conference will be December 23rd, 9 o'clock.
Your Honor, this is Richard Zachary Wagner. He's before the court on 25 CF 894, 25 CF 895, 25 CF 898, 25 CF 899, 25 CF 902. We're going to request a continuance. Your Honor, I have requested depositions, but I'm still waiting on a date for depositions.
Okay. All right, State, have any objections?
No objection.
All right, Mr. Wagner, you understand that waives your right to a speedy trial? Yes? Okay, I just know we've talked about it before. And then we've got the 23 CF 2526, that's just on, for I guess, status until we get to the end of the other ones. That's the trial case. All right, Mr. Wagner, December 23rd, we'll see you back on that date.
Did the court get the report on Mr. Walterman?
Yes, I read it yesterday. I think y'all just sent it to me yesterday, and then. What do we want to do with Mr. Walterman?
Your Honor, I would ask the court to adopt the findings of Dr. McDonald, find him incompetent, and
Or are y'all stipulating based on the one report?
The state is, Your Honor.
Okay.
Yeah.
and follow her recommendation.
At 9:13 last night, I read it. Based on the stipulation of the parties to go forward on a competency hearing based solely on the report of Dr. McDonald. Again, courts reviewed that last night when it came in. It recommends, or it opines that Mr. Walterman is not competent to proceed. That he likely can be restored. Recommend that he go to the Department of Children and Families for treatment of psychiatric symptoms as well as his restoration. The court will follow that recommendation today. And point out, obviously, as well as I think our last court date, we saw some of the things that were discussed in Dr. McDonald's report. In fact, she cited that she had watched the video of it as well. So if you all want to get me in order,
Yes, Your Honor.
finding that he's incompetent and we place with DCF for purposes of competence restoration.
Yes, Your Honor.
Thank you, Mr. Walterman. You say Watson?
First name? John. Okay. I'm gonna find the.
So the state is offering you.
Oh, that's the Parnell.
Okay. So I will write it up real quick. Yes, sir.
Yeah, I looked it up at the time. He
Yes.
just filed some things like a couple of days ago.
The state won't go forward on the failure to show here? The state will not.
I'll just write it up real quick.
Did you reach out to him then? What's his first name? Ralph Parnell? I think he goes by Trey or something like that.
And I discussed the case with Mr. Parnell, but I don't know where he is today.
Okay.
Go here.
Mr. Watson, I'm gonna have you just slide over here next to your.
Gregory Austin.
Judges, this is going to be Jonathan Collins. He has two cases on the docket, 25 CF 1041, 24 CF 2510. We had depositions on October the 14th. 4 out of the 10 witnesses did not show, And then we also learned during the depositions that on the 25 case, there's a cell phone download that I'm supposed to be getting that I don't have yet. So what I would propose to do is to set this case for plea or continuance on Monday, November 3rd, to see if we can work something out based on the information we've already learned.
Oh, I thought it was Joseph Carroll.
So plea or continue?
Yes, sir.
All right. November 3rd, 9 o'clock for plea or continue. See you on Monday, Mr. Collins.
Judge, it's going to be Joseph Carroll. Case number for the record is 24 CF 2383. We had depositions on October the 20th. Due to some technical difficulties and because one of the witnesses was unavailable and the beginning witnesses ran a little bit long, we weren't able to complete the depositions. So at this time, we're going to ask for a continuance to the 1223 docket.
There's no objection.
How many more witnesses do you all have?
I have, well, the one witness that's unavailable is out on maternity leave till January, so unless that changes, she's the DNA expert.
Able to do that remotely, or I'm not saying you have to, obviously you has the right to do it differently.
I got a call from the supervisor. I'll have to talk to her and see if she's available.
You're asking for 1223?
Yes, sir.
All right, you understand that, Mr. Carroll?
Yes, sir.
All right, December 23rd at 9 o'clock. Myself a note. All right, see you back on that day.
Thank you, Judge.
We just have the state to sign it, but we're ready.
Say again?
The state just has to sign it, but we're ready otherwise.
Mrs. Watson. I think we can go forward with it when she comes in. I'll ask her if that's her agreement. He can sit if he needs to, Steve. Can you see if you push that microphone down towards the, well, here's Miss Leone. Just sign it.
Okay.
I think we need your signature on Watson. No, it's okay. Handle two while we're waiting. Okay. Thank you. All right, Mr. Watson, can you see me okay?
Yes, sir.
Okay, can you raise your right hand?
Yes, sir.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, can you state your full name and date of birth, please?
John Charles Watson, 2/2061.
All right, and Mr. Watson, you're here in 25 CF 597, where you're charged with possession of controlled substance, third-degree felony, 5-year max, and possession of drug equipment, which is a first-degree misdemeanor, 1-year county jail max. I've been handed a plea and sentencing agreement that calls for you to plead to just the misdemeanor, count 2. The state would then dismiss count 1, and it's credit for time served and some costs, $270 court costs, 100 and, why is it 150?
It's probably just, it's $50 PD fee
Okay. Oh, okay, I see. Yeah, the second slash of your dollar sign kind of looks like a 1 there. All right, so 270, 50, and 50. And then I'll give you some time to go pay those court costs or set up a payment plan.
Thank you, Your Honor.
Okay. All right, is this what you want to do today?
Yes, Your Honor.
Did you go over this plea form with your lawyer?
Yes, sir.
All right, did you understand and sign it?
Yes, sir.
You happy with your lawyer's work on your case?
Yes, sir, I am.
All right, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir, I am not.
Any mental health issues right now?
No, sir.
Anyone force you to do this?
No, sir.
Anyone promise you anything to do?
No, sir, they have not.
Excuse me. Sorry about that. Do you understand by entering a plea that there won't be a trial of any kind?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
Okay. And what is your plea to the possession of drug paraphernalia or equipment?
No contest, sir.
All right, I'm going to accept your no contest plea as to count 2. Time served, $270 in court costs, $50 application fee for the PD, and $50 cost of defense. I'm going to give you 90 days to pay those costs or set up a payment plan. The state have an announcement on count 1, the possession of controlled substance.
Yes, state dismisses count 1.
Okay,
And the state's not pursuing the failure to appear?
That's correct, Your Honor.
okay. State not pursuing the failure to appear. All right, Mr. Watson, you've got 30 days to appeal, but this should end your case today.
Okay, thank you, Your Honor.
You're welcome.
All right, you're done.
Thank you, Mr. Very much.
Mm-hmm.
Thank you. Which Williams?
Jeremy Williams. Your Honor, this is Jeremy Williams. He's before the court on 25 CF 702. Your Honor, last trial cycle, we had set depositions, we had depositions, and we were able to depose everyone but the victim. We tried to
It's
set...
out of state, right?
Yes, we tried to set depositions this time, but we're still waiting on a deposition date, so we're going to request a continuance to 12/23.
Okay.
Is there anything that's going to have to be done for the out-of-state victim to be deposed, subpoena or anything like that?
I think we'll have to go that route, yes, Your Honor.
You agree, state? I'm just,
No, yes, Your Honor, whatever it needs to be
it's
done.
just a very slow process if you got to subpoena someone out of state because you got to get it through a court of competent jurisdiction in that area. It's,
I guess if, well, normally I would communicate with them without the need for the defense to file a
Subpoena
subpoena for that case. If we have to do via Zoom, I don't know what.
That's fine.
all right.
Yeah.
I'm putting on 12/23, 9 o'clock. Let's get that last deposition done. I will see you December 23rd, Mr. Williams.
Mr. Williams, that's Kimberly Lehman.
Who's on Gregory Austin?
I am, Your Honor.
All right, so my assistant just reached out to his office, said it wasn't on his calendar, and he can either hop on Zoom or we can reset it for tomorrow.
I'm fine with resetting it for tomorrow, if court prefer.
Are you gonna be in here in the morning or afternoon, or both?
I'll be both, so.
Okay. All right, I'll just gonna put it on for the morning in that Gregory Austin case. Good evening.
Hey, Judge. Judge, this is Kimberly Lehman. Judge, give me just 1 second on it because I
Wasn't
don't
she under someone else?
have her, well, I was going to say, I don't have her on my list, but I think that
She was listed, she had someone else listed as her attorney. Was it Miss Rivers or is it Miss?
It should be me, Judge.
Oh, I know, it's just, it's wrong on the docket, that's. Go ahead, I'm sorry to interrupt you, Mr. Lane.
Give me just one second, Judge.
I've got his number 74 on my docket, and it's listed under Miss Rivers, so that was the issue.
Trying to get. Judge, let me do this. I've got some documents in the file that are a little bit
Excuse me.
confusing. Check. Stack. Judge. Judge, I think we can resolve it. Considering though how late in the day it is, can you give me a few minutes? Judge, let me see if I can draft something up on it.
Okay.
I did not have it on my list for today, although apparently I had it at some point because I pulled the file.
What is the resolution you are talking about?
What we're talking about is 2 years on probation. It does call, though, for an adjudication.
If she pled today, she could potentially be out today.
Yes, sir, in ECLC.
All right, let's get it resolved.
All right, thank you, Judge.
All right, we'll pass you, Ms. Lehman, for a little bit. I know this is your second time up already, just so you can get the paperwork done, and then y'all can talk about it, and then we'll take your case and hopefully be resolved today.
Okay.
There's not like a GPS or anything else weird like that on it, right?
No, Judge, I didn't see anything to that effect.
I just don't want to go through all this, and then it turns out we can't get the GPS monitor on you fast enough, and then you don't get out anyway, but.
I'll tell you what, ma'am, I've got some, this is a copy of the rights form that's attached to the plea agreement. Let me give that to you, let you read it while you're waiting, and that way things will run quicker and smoother when you get back up.
Okay.
All right, thank you, Ms. Lehman, we'll see you in a little bit. All right, who's next? I've got the other email, Peggy Casper.
Peggy. All right, Judge, let me flip back to Ms. Casper. All right, Judge, I emailed Ms. Leone basically seeking some kind of a break for her. It's a trafficking charge. She's currently in ECLC. Can we maybe pass it until Monday and see if we can get it resolved?
Sure. All right, November 3rd, 9 o'clock, clear continuance.
Thank you, Judge.
See you on Monday, Ms. Casper.
Mr. Allen.
Judge, I had scheduled a
Evaluation.
NGRI evaluation on Mr. Allen, and the evaluator is of the opinion that he's decompensated, And unfortunately, apparently I need to do another authorization for the competency eval. With that said, though, Judge, I'm thinking it should be relatively quick because he's already seen the guy and given me an opinion that he's decompensated.
What doctor is it?
Dr. Zeman.
All right, so what do you want to do with it?
I'm going to ask to continue it for that purpose.
December 23rd, 9 o'clock. Give me a copy of the report once it comes in.
I will, Judge.
All right, thank you, Mr. Allen.
Judge, this is going to be a negotiated plea. No, it's.
Mine.
Oh. Did you give me a score sheet with it?
I have one right here if you don't have one.
Yeah, I don't. Thank you.
And for the record, Judge, he's going to enter his plea today, but we're going to set up imposing sentencing so my victims can be present.
Okay.
That's correct, Judge. Also, he's in ECLC and wants to graduate. That's going to be December 16th, I think. So we'll want a date after December 16th.
All right, so you wrote it in here, so it's a total of 12 years DOC followed by 20 years probation. So that's SO probation.
That's correct, Judge. There'd been a miscommunication where I thought that 2 years had come off, and I was wrong about that, so I had to add it back in.
All right, Mr. Booker, can you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Ricky Otis Booker, 5/16/86.
All right, Mr. Booker, you're here. All right, so 305 was consolidated into 354, so they're all on the same case number? Is that right?
That's correct, Judge.
Okay. All right, so you had the original 305 case, which was child abuse, third-degree felony, and then in the 354 case, it was child abuse, third-degree felony, sale, manufacture, deliver marijuana or cannabis, third-degree felony, unlawful use of a two-way communication device, third-degree felony, and then you've got 2 counts of lewd and lascivious battery, second-degree felony, punishable up to 15 years each, lewd and lascivious molestation, second-degree felony, 15-year max, another count of lewd and lascivious molestation, 15-year max, promoting sexual performance by a child, second-degree felony, 15-year max, 2 counts of unlawful tattooing, which is a second-degree misdemeanor, punishable by up to 60 days in county jail, and contributing to the delinquency of a minor, 1 first-degree misdemeanor, punishable by up to a year in county jail. Do you understand your current charges, Mr. Booker?
Yes, sir.
Okay. All right. The plea and sentencing agreement between you and the state calls for you to plea to 1 count of the child abuse, 2 counts of lewd and lascivious battery, 1 count of lewd and lascivious molestation, 1 count of promoting sexual performance by a child, and then the state's going to dismiss the sale, manufacture, delivery, the unlawful use of a two-way communication device, the other L&L molestation count, the 2 unlawful tattooing counts, and the contributing to delinquency count. In return for your plea, although the sentence won't be imposed today as discussed because the victim wants to be here, it'd be count 1, 5 years DOC, count 4, 7 more years of DOC consecutive to that, followed by 2 years of sex offender probation, In count 5, 13 years of sex offender probation consecutive to counts 1 and 4. Count 6, 5 years of sex offender probation consecutive to counts 1, 4, and 5. And count 8, 5 years sex offender probation concurrent to count 6. For a total of 12 years in the Department of Corrections, followed by 20 years of sex offender probation. Is that your understanding of the agreement you made with the state, Mr. Booker?
Yes, sir.
Okay. And I'm showing a guideline sentence would have been 143 months and 143.475 months. So this is just a fraction of a month above guidelines. Because 144 would be 12 years, right?
I'm sorry, Judge, you say those numbers again?
The guidelines I've been given says 143.475 months. So since it's basically 12 years of DOC, it's about half a month over the guideline.
Yes, Judge, it's a guideline.
So it is a guideline. All right, just wanted to make sure I've got the numbers correct because of all the changes as far as what he's pleading to. All right, Mr. Booker, is that the agreement that you've made? Is that what you want to do today?
Yes, sir.
Okay. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Have you talked about the sex offender probation requirements?
Yes, sir.
Okay. Have you gone over all of those issues as far as it's here on page 2? Did you go over that with your lawyer? All right, since I'm not going to be announcing your sentence today, I just want to make sure you understood it all, that you'll have to comply with all of those rules while on sex offender probation. All right. Did you understand the plea agreement? And did you sign it?
Yes, sir.
All right, and are you satisfied with your lawyer's representation and advice in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea? You understand that by entering a plea, there won't be a trial of any kind. You understand you're giving up your trial rights, which are listed on page 2 and going on to page 3 of the agreement that you signed. Do you understand that you're waiving all potential defenses that you may have made or may have had? And do you understand that by entering this plea that you could be deported if you're not a U.S. citizen? All right. And let me just make sure I give you go through each count again. As to the count of child abuse, what's your plea?
No contest.
As to the counts of lewd and lascivious battery, 2 counts, what do you plea?
Oh, no contest.
All right. 1 of the counts of lewd and lascivious molestation, what is your plea?
No contest.
1 count promoting sexual performance by a child, what is your plea?
No contest.
I'm going to accept your no contest pleas as freely, voluntarily, knowingly given. State have an announcement on the other counts.
Yes, Judge, in 24 CF 354, in exchange for a plea, we would announce a dismissal of counts 2, 3, 7, 9, 10, and 11, as well as the child abuse charge in 24 CF 305.
That had been consolidated, but just to keep it separate for that purpose. All right. All right, and when would you like to schedule the sentencing for Mr. Booker?
Judge, after December 16th, he wants to attend the graduation at ECLC.
Can I give y'all, I've reviewed the guidelines, can I give it back to you? Otherwise, we're going to have to
Yes,
print it
Judge.
so I can sign it again. Mr. Williams, if you could give that back to Ms. Barrickman, or if you want to hold on to it, doesn't matter to me, but just make sure someone has it for when we come back. As far as, how long do you expect the sentencing to take since it's agreed upon?
Not long.
They just
Judge.
want to be present, Judge, and we weren't sure with everything going on today, if that
I
would
can
happen.
put them on the December 23rd pretrial, because I don't really have much after that until January.
Okay.
Let's put them on December 23rd for purposes of sentencing.
There were two things that
All right, we'll see you back on that date, Mr. Booker.
Thank you, Judge.
the new cases on staff. That's all, because it's a hybrid position.
Judge, State's made an offer in Mr. Clary's case. There were some issues that Mr. Clary had with some of the requirements, and he did want me to specify that as to count one, the arson case, it would be an Alford plea. He still maintains his innocence on that, but feels like it'd be in his best interest to resolve it. What I emailed you about was he lives in Laurel Hill, and he's on disability. So going to drug classes and stuff like that is going to be very, very difficult for him. Is there anything else that we can do along those lines?
Well, my
Or do you want to, well, I want to resolve it today if we can. So.
I'm just saying that my concern is his mental health.
Yeah, and I understand that. I tell you what, Judge,
What the disabilities for?
yeah, he's right.
part
And
of
she
what's
just wants to make sure that you're getting treatment, counseling, and stuff like that to help with that.
Oh, yeah.
Are you currently taking medication?
No, I don't have a doctor.
Okay.
My doctor that I was seeing that took my insurance quit, went to a different company, and they didn't take my insurance no more, which is Medicaid. So I don't have a doctor yet, and I don't have a vehicle.
All right.
And then I did this bad stuff with the drugs that, you know, because of being my home burnt, and it took me.
In my
drugs. But I did call the police on myself when I tried the drugs. I called the law to myself and told them to take me to the Baker Act hospital, and they brought me here to the jail and put me in their hospital or their holding tank. But after I took the drugs, I knew they wasn't for me. You know, I didn't have a drug problem before, and I tried them, and that wasn't for me. So.
His uncle, cannot he take him to? where he
I
needs to
don't know.
go?
Yeah, my uncle, he's 70 years. Just had a birthday yesterday. He's like 70 years old. He'll take me as he can. Yes, ma'am.
Mr. Williams?
Because I know they stopped my
Mr. Cleary.
disability.
Hold on, Mr. Cleary. I don't want you to say anything further that's going
Oh, yes,
to
sir.
affect your case.
You're not going to have an issue with him on that thing. He's kind of things like the actual issues. All right, so Judge, we're going to change this to just time served.
In the arson case?
Yes, sir. Yes, sir. Again, it's an Alford plea for him on that.
Even about that, Your Honor, we did speak with the victim, is his uncle, and he confirmed that he really believed it was an electrical malfunction and not the defendant
Would you be-
intentionally placing this house on fire.
Well, that's what we'd maintain. Would you be willing to dismiss then?
I'll say criminal mischief,
Okay.
misdemeanor.
All right.
Yeah, the power company come out right before I got, don't say nothing else.
I think y'all are coming to an agreement. I'm not sure if you talking more about it's going to make it better.
Oh, yes, sir. No, yes, sir.
So Judge, I'm going to change this to time served with an adjudication. And,
So it's just for the two different drug charges?
well, time served on the drug charges, lesser included criminal mischief
the 601 case.
Yes, sir. All right. Mr. Clear, you remember I read this to you last night?
Yes, sir.
Okay. Did you understand all of it?
No, sir, but I mean, I trust you.
Okay. All right. The judge is going to ask you some questions about it, okay? But let me get your signature there.
Where's that at?
Right here.
All right, that's it here. Yes, sir.
All right, I'm going to go ahead and date it. Is that okay with you?
With me?
Yeah, or is it okay if
Yes,
I
sir.
put the date on it for you?
Yes, sir. I don't know what the date is.
It's 10/29.
I know yesterday's my uncle's birthday because I had talked to him on Saturday, so, or yesterday.
Okay. Okay. All right. We're going to further amend that to possession of paraphernalia on the 2 drug charges, so a score sheet will not be necessary. And you just have misdemeanors. Okay? No felonies.
I appreciate that, sir.
Well, you can thank Ms. Leone as well. all
Yes,
right?
ma'am.
Or probably thank her more.
Yes, ma'am.
All right. I'll give you a court cost number. What are you going to want to do with court costs for him? And we're going to figure out the number, but do you want to give him a payment plan or just judgment?
Let's give him the chance to do the payment plan, Judge. If he fails that, it'll go, well, you're talking about judgment or judgment and send it to collections?
Collections.
Let's give him a chance for it not to go to collections.
All right, Mr. Clary, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You're here on 3 cases, 25 CF 601. Your initial charge was arson, second-degree felony, punishable up to 15 years in state prison. And then you've got 25 CF 1331 was a possession of methamphetamine, third-degree possession of methamphetamine in 1332. I've been handed a plea and sentencing agreement that calls for you to plead to criminal mischief, first-degree misdemeanor, and 2 counts of possession of paraphernalia, also first-degree misdemeanors. And your sentence would be time served, adjudication of guilt, and then we'll get you some court cost numbers in just a bit here. Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Sir?
Did you go over this with your lawyer?
Yeah, he read all that to me yesterday, last
Did you
night.
understand it all? What, was there something specific in here that you don't think you understood? Things have changed a little bit. You're not doing, probation or anything like that.
Just the money and all. With me being in here, my disabilities got stopped, I know. Because I'm short Hess, and I'll have to get my uncle, and he's old, and he's got prostate cancer and all.
Okay.
So I got to get him to take me, because my mom and dad, they've recently died right before, my daddy died right before all this, right before my motorhome burnt.
Sorry for all that.
But
Is there anything that I can explain to you? I want to ask you some questions.
Yes, sir.
And just try to answer each one that I give you.
Yes, sir.
Are you satisfied with your lawyer?
Yes, sir.
Did he do a good job for you?
Oh, yes, sir.
Okay, and are you currently under the influence of anything like alcohol, drugs, medications?
No, sir, I never had a problem with alcohol nor drugs. But when I tried them, they're not for me.
I understand, it can be a yes or no.
No, sir, I'm at the jail. I'm not, got no drugs.
Oh, I understand.
Yes, sir.
Are you currently suffering from any mental health issues?
Yes, sir.
Okay, and what is that?
That's what my disability was gave to me for, was part physically and part mentally.
Okay. Do you feel like you know what's going on
Yes,
here
sir.
today? Do you understand that you're just going to pay some costs and they're going to let you out of jail?
Yes, sir.
And so that you understand there's not going to be any probation?
Yes, sir.
All right, and that's what you want to do?
Yes, sir.
Did anyone force you to do this?
No,
Take the
sir.
plea?
No, sir.
Did anyone promise you anything in return for your plea?
Yes, sir.
What did they promise you?
Probably that I could go home.
Okay, so it's going to be time served, so that's accurate, but
Yes, sir.
no one promised you anything other than what we've talked about?
No, sir. No.
Okay. Do you understand there's not going to be a trial?
Yes, sir.
And do you understand you're giving up all your trial rights? Right to plead not guilty, to right to question witnesses against you, right to have an attorney represent you at that trial, a right to present any all defenses
Yes,
that you
sir.
may have. You understand you're giving up all those rights?
Yes, sir.
All right, and do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
Okay. All right, and what is your plea to the criminal mischief and the 2 counts of paraphernalia?
That no
No
contest. No
All right.
contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given on the criminal mischief and the 2 paraphernalias. Give you credit for time served, adjudicate you guilty on each. Court costs, total of $1,010.
How long I got to pay that?
I'm going to give you 90 days to, hold on,
Yes, sir.
to either pay them or set up a payment plan with the clerk's office.
Yes, sir.
If you don't set up that payment plan or pay them,
Yes,
it's
sir.
going to go to collections. You understand?
Yes, sir. And I go back to jail.
No, you won't go back to jail. We don't jail people for, well, some other courts will put you in jail for not paying money.
I'll
Try not to do that in criminal court unless we can show you're purposely not paying
I'll get it.
but-
I'll get it paid somehow.
Okay, I appreciate it, Mr. Clary. Any other questions for your lawyer or for the court?
Yes, sir. Or no, sir.
No, okay. All right, I don't need your fingerprints. I'm just going to tell you you've got 30 days to appeal, but if there's nothing else holding you, you should be released today.
Oh, yeah, that'd be good.
Mr. Clary, when you get out and go to the clerk's office, they'll take the amount that you owe, they'll divide it by 10, and they'll want you to pay that amount each month.
Okay.
For 10 months. Now, if something happens, you can't do it, it'll just go to collections like a bad credit card debt or something like that. You're
Oh,
not
yeah.
going to
Oh,
go
I
back
got-
to jail.
I got 10 months to pay it.
Well, yeah, you pay a little bit each month for
Okay.
10 months. They'll
Okay.
explain to you in more detail.
Okay.
Okay?
Yes,
All
sir.
right, thank you,
All
Mr.
right.
Clary. Good luck.
Yes, sir. Thank you, sir. Thank you, ma'am.
Dice. No dice. Who's talking to you right now? Danny Plum. All right, Joseph Gainey, 25 CF 411. What are we doing with Mr. Gainey, Mr. Williams?
All right, Judge, I've been trying to get the state to go back to the original offer. They won't do it. So it may wind up having to be a trial. Can we pass it until Monday, and I'll go out and...
The plea trial?
If I may say something, if that's all right?
Sure.
I believe that the state probably won't go back on the original offer because they're taking the FTA as a sign of disrespect to the courts. If that is in fact the case, it wasn't disrespect. It was a miscommunication between myself and my public defender. I accepted accountability for it, as you remember, Judge, at first appearance, and have sat 4 months incarcerated for it. Again, I thought I had the okay to go to work. Apparently not. And I've done 4 months because of it.
If I may,
Go ahead, Ms.
that's not the case. The reason why the offer was revoked is because when I first made it on March 12, 2025, I stated, and it's highlighted, if taken at arraignment, plea to lesser included possession count 1. If not, if FTLE confirms drugs weight, then 3 years DOC min-man. And it came back positive for trafficking amount of meth, the FTLE. So that's the reason why I'm not going back to that offer.
That was never stated to me when he told me that. He told me that if we put it off, that he could take it to trial and beat it.
No.
And now I'm saying
What I
that we
said is that we get discovered, we find out how much it actually weighed, and make sure it actually is what they say it is.
But if she's saying that would be the time that the offer's removed, why wouldn't that case come up? You never stated that fact to me. That would have been an important
That it
factor.
was going to be revoked at that point? Judge, normally I would say something like that if it were on the offer. I'm not a fan of people buying a pig in a poke. I can go back over my notes and look at it. Does the court want to set this for a Nelson or something?
I'm not sure
Did
it's
he
in
just
Nelson that
say-
I think it's maybe confusing, but, I mean, I'm looking at the notes, the clerk's minute sheet from his arraignment date, and, which was March 27th, and then we just put it on April 10th at 1:30 so he could think over the offer. Now, on April 10th, I can't pull up the sheet. Hold on. Try a different way. I think instead of going straight to a pretrial conference, we put in another arraignment date so he could think about the plea offer is what happened.
That is correct. You're
I can't see the clerk's minute sheets from the day that we came back on April 10th. It's not coming up in that system. I'm going to try and pull it up in Odyssey. Doesn't indicate anything other than he was here and there's a not guilty plea and he was put on June 23rd. June 23rd, it was passed plea or continued to June 30th. That's when he didn't appear for court.
I did show up, and he held the door for me as I walked out of the courtroom.
Yeah,
It's literally on video. I'm so sorry that happened and the miscommunication in the hallway took place, as it apparently has been doing since we started this thing.
And I told the judge that I had seen you that day, okay?
Like I say, I've accepted accountability for the miscommunication. Your Honor, state if I would take double the probation that you originally offered to get this thing over with.
There's the thing, Mr. Gainey, we're not going to negotiate it in the well of the courtroom at this point. If y'all want to talk about it, we can come back another day, but, you know, we've got more cases to handle.
I
We've been
understand
doing
that.
this since 9 o'clock. This is not the time to negotiate. The time to do that is before court.
With all due respect, and can I ask the courts, can I get back on my bond that I was originally on?
I mean, I'd have to go back and look into it.
You did the first appearance on it, Judge.
Well, then I probably made the decision that I wasn't going to put them back on bond based on what happened, but it hasn't come back in front of me with a bond hearing or anything like that. It's not addressed for today. You can't just ask for something without notice.
He come August 27th and asked me, or talked to me in the jail and said we had court on the 26th. He showed up at the jail, said we had court on the 27th.
Of August?
Of August, Your Honor, and told me that we were going to ask for a bond then. It's been 2 more months. He hasn't been to the jail to see me or responded to letters that I've written to his office. He doesn't respond to my loved ones or my friends, and even a key witness in in the case. That's why I'm asking for the bond, so that maybe I can get a chance to maybe figure this thing out, have more time with my public defender, maybe. I showed up to every court date on time.
I'm not negotiating with you. That's not how it works, Mr. Gainey. You can either continue it, you can plea, you can set it for a different date to do one of those things, or you can set it for trial. But I'm not entertaining oral bond motions when there's been no notice of it.
Judge, I haven't scheduled a bond motion on it because we had that whole thing where you viewed the court smart, talked about what had happened and that you gave him a $10,000 bond on it. You already addressed everything that I would raise in the bond motion. I can go ahead and file one.
You've got a cash professional bond right now.
Yes, sir, but I can't afford it.
Well,
That's what I can't get anywhere in the court.
All right, again, this is not a negotiation, Mr.
I
Gainey.
understand.
You left court. You didn't stick around. I gave you a bond, which normally, can I finish before
Yes,
you
sir.
start trying to talk again?
Yes, sir.
It's really frustrating when someone's asking me for something, when I'm trying to explain it, then all they're doing is not listening and waiting to talk next. I gave you a bond. So I don't see any reason to reduce it at this point. You're charged with drug trafficking, all right? Right?
Allegedly drug trafficking, yes.
I didn't say you're convicted of it, did I?
No, you didn't.
All right. They just said that the FDLE came back and it's a trafficking amount of weight. So you can go to trial or you can take a plea or you can plead straight up. But yeah, this is not a negotiation with me, Mr. Gainey. That's not my role here.
Okay.
I gave you a bond despite the fact that you missed court.
Went to court. How do
All
I
right.
file for a Nelson hearing? Is that through him, or?
Write down what you think the problem is and I'll address it as soon as it comes in.
I greatly appreciate that, Your Honor.
What day do y'all want to put the case on?
Well, since he's going to do a Nelson hearing, Judge, I'm going to move to continue it. He's also raised the question of another witness. And I think at this point, I've exhausted my abilities to try to get the state to come down off of the trafficking. It did come back just as.
Mr. Gainey, I would suggest getting the Nelson
Yes, sir.
inquiry written down quickly, send it in. I'll try to get it set for a hearing. I can't set things for hearings until something's actually been filed.
Yes,
So
sir. I just filed it straight with the court's office.
you just send it to the court and they'll forward me a copy of it. Anytime something comes from a defendant, even if they're represented, but if it's regarding something like a Nelson hearing or a Ferretta inquiry, something like that, they send me a copy of it and I set it for a hearing as soon as I possibly can.
Thank you, sir.
All right. And I'm sorry if I'm getting frustrated with you, Mr.
I
Gaines.
understand.
Just- We've been through these things. I gave no bond KPS at the first appearance. It just happened to be me, because I only do first appearances a few times a year.
Yes,
And
sir.
I gave you a bond based on what I heard. Now, we've kind of looked at it, but, I'm not sure what your bond was in the beginning.
It was an ROR.
Yeah, which I don't understand why anyone would ROR a trafficking case.
My understanding is that first appearance court establishes probable cause for the original arrest.
I understand that, but I wouldn't give an ROR bond on a trafficking case.
Even if you found no probable cause?
Was probable cause found?
Apparently not. I got the ROR.
No, it probably.
I'm sorry, that was,
All right, we'll see you back on 12/23, Mr.
Yes, sir.
Gainey. This is getting a little bit beyond the pale at this point.
thank you.
Mr. Dyke.
Okay, Judge, so if you'll recall, we got Mr. Sawicki, retained him. I went out with him, viewed the images in question. We've had a meeting with me, him, and the defendant. I reached out to Mr. Sawicki to ask him what he could definitively say, and I did not hear back from him until this morning in court. He advises that he needs a couple more weeks. The defendant has expressed several times that he feels like the case is being rushed. So
Rushed? It's over 4 years old.
Yes, sir. Yes, sir. So it's not a situation where he's clamoring for a speedy trial. I am going to ask for another continuance so we can get something final from Mr. Sawicki. If it's helpful, I'll have him do a report, or I will notify everybody and list him as a witness. If it's not, then I won't. But I'm wanting to hear the final thing. Mr. Dykes has also indicated that we sent him, he says it's his first copy of discovery. Our files are showing discovery was, that we had so far was previously sent. But another round was sent to him, and he's got some motions that he wants me to file on the case.
Such as?
Judge, I know that there was some in his correspondence, he didn't detail them, so I'm going to have to meet with him. I know that he has mentioned before a concern with the fact that you handled the dissolution of marriage, he believes.
I did. I have no recollection of that, but I can take a look at it. I think that's one of those almost, I don't know, I want to call it catch-22, but I don't have any recollection of it until you bring it up, and now to my bias because of something that I don't even remember until you bring it up.
Was it a dissolution or an injunction?
I filed
both?
for divorce, and she tried to jump the divorce. This is the whole reason why we're sitting here today anyway. I filed the divorce. It got pushed through. She went and hired an attorney. Judge Oberliesen did give me, the attorney made some mistakes, and I was able to get an attorney, and we dealt with it. But if I may
Yeah.
address Your Honor.
Sir, I don't have any recollection what you're talking about. And it's not personal, Mr. Dykes. I deal with literally thousands of cases a year, so I just don't remember every one of them, especially if it was years ago. But you can go ahead.
I've just, as you can tell, I've had multiple attorneys and representatives from the state of, sorry, I'm not good at this. I've had multiple public defenders, almost 6, 7, 8, something. Each one gets in and says, we're doing this and we're going to continue, we're going to do this, and then a lot of stuff isn't getting done. I've got a list of witnesses that should be on a list that isn't. Got other witnesses that should be on another list that aren't.
These were lists that were provided to previous public defenders?
Absolutely. And I understand that you, for all sakes and purposes, Jay has just got here. Mr. Williams has just got here 6 months ago, and I know he has 100 and something cases he's got to deal with, so I wouldn't expect him to be able to jump and call up 10 or 20 different people that lived in and around us.
Yeah, I would have to know about them, and I haven't seen any notes in our official.
We discussed the other issues that I have that are an issue for you. And
yeah.
I don't think I should discuss them openly, or.
Okay.
I don't.
Well, but here's the thing, Mr. Dykes, things have to be discussed at some point between you and whoever your lawyer is or
understand.
what.
I've seen him today.
Mr. Dykes, is my microphone not working at this point? You just did I interrupt you at all when you were just talking until I finally stood up to say, you've got to do something in your case. Your case is over 4 years old. We've repeatedly talked about these things. I understand you had at least one attorney who didn't seem to want to do anything on anybody's cases. So I've given a lot of leniency and grace because of that. However, this case is 50-plus months old. So when Mr. Williams tells me there's some motions, but we don't even know what they are, we have to proceed on those. I mean, people should want their day in court and not just push these things off for 4 years and 5 years.
Me until today.
Well, that's not
2 months.
entirely true. I wasn't able to see you to prep you for this hearing until today. But I went out to see you after going and reviewing the materials with Dr. Zawicki, and I went out to see you again after that. We had the meeting with Dr. Zawicki, and I went out to see you again after that.
I only saw you, Sawicki was the last time I saw you.
When we had the...
When I talked to
All
you.
right, this is what we're going to do. Let's put it on next week. It's not for, it's going to get continued from next week, but I want y'all to have some sort of plan.
Yes, sir.
Because I'm not going to do this every 2 months. We come back and it's the same things.
Yes, sir.
Mr. Dykes, this is crunch time for your case. If you have anything you want Mr. Williams to do, you have to tell him about it. Write to him about it. Make a record of it. If you feel he's not doing things that you've asked him to do, then bring that to my attention, and I'll address whether or not he's failed to do something or has been ineffective in some way. The issue is, and frankly, it's an issue we've had to clean up in this division for the past 10 months, is that prior counsel that you had and other people had wasn't simply doing his job. And I'm trying to clean that up.
I-
But I can't just say, well, because 18 months were wasted, you need another 18 months to fix it. You understand? And again, I don't know anything about your dissolution case. I don't have any recollection about it. You would have been in custody the entire time, and as quickly as I could look it up, it looks like it was a settlement agreement. So I don't have any recollection of that. If that's a concern of yours, you can certainly bring that up in a written motion. The problem is, you've known about this for years and haven't brought it up to this point.
Your Honor, I was asked by the first attorney, Stokes, to sit back, shut up, and let us do the work for you. Your Honor, my piece of paper here very specifically says that I would like a Nelson hearing.
Okay, write it down why.
And I will file the motion as my assistants, the people that have helped me the most in my pod have requested that I do that.
Well, I would be wary of taking advice from people who are behind bars and
Yes, sir.
haven't gone to law school and haven't practiced law. If you've got a concern with your lawyer who has, write it down, we'll have a hearing. But I'm not going to keep continuing this case. That's why I ask what still needs to be done. This is not just your case, Mr. Dykes. I ask this about every case that I see is getting too old. What else has to be done? Oh, we have a depot. Who? And I write it down. I write it down in different colors. I keep every single docket I've ever had in this division, and I go back and look at them all the time. I go back and watch hearings all the time to make sure that people are living up to what they promised me when they come into court. So that's why I ask the questions, because I want specific answers, because I've seen these cases get pushed and pushed and pushed, and it's not fair to you, Mr. Dykes, that that's happened to you. It's not fair to alleged victims in cases. It's not fair to the lawyers who are trying to deal with this. These things have to be dealt with in a professional manner, and I'm trying to make sure that happens.
Yes, sir.
But if you've got concerns with your lawyer, bring them to my attention, and I'll certainly address them. I don't have a problem with that, but I need to know what needs to be done still in the case. We have to have a little bit of a pause button if you're asking for a Nelson inquiry, so I can handle that, because if it turns out there is a situation between you and your lawyer that needs to be addressed, we don't really want a lawyer under that circumstances to continue working on a case to find out that you didn't want him to do certain things, just for example. So make your Nelson inquiry, as far as this is what I think has been done improperly or not done when I've asked or to be done, and we'll have a hearing on it as quickly as possible.
I mean, I don't even know if I'm capable, my mental health issues, I've had these disabilities my entire life, and I mean, I've asked for this stuff through Timothy Gibbs. I've asked for this since Olivia Ramsey. I've continually asked about my mental status, about all this stuff, but I mean, the best I can do is utilize the people around me, because if I talk about it on the phone,
All I've asked you to do is put it down on paper.
I will do that, sir.
So I know what we're dealing with, so Mr. Williams knows what he's being accused of, so the state can prepare if they need to do anything about it. I just need to know what it is. You know, the idea of having these hearings where no one knows what's happening until we get there and everyone has to do things by the seat of their pants is not how the system's supposed to work. There's supposed to be notice and due process and fairness, and that's what I'm trying to ensure here, despite what's been done in the past.
Yes, sir.
So I'm sorry if I'm getting frustrated with it, Mr. Dykes, but again, your case is very old, and every time we're here, no progress is being made.
That's not Your Honor, if I know they're busy, but I can't make him come see me. I
And
can't
put it on a piece of paper and send it to the clerk's office. They give me a copy, and we'll address it.
They don't even want to give us copies at the jail.
Copies of what?
Of anything. I mean, I've written a bunch of stuff, and I've sent it to the office, and they never receive it as well. I've even written it when we used to get carbon copy paper through the nurses, and those never got back. But I don't know, communication, I believe it should be back and forth, and I can't get responses, you know.
Well, then you can simply tell me that, Mr. Dykes, but put it on paper. There has to be a record of it.
So I will file a motion for the Nelson hearing.
Sir. I mean, I'll give you the hearing. It's basically put it on paper what you want me to inquire into, so that way we know what it is.
I do need a little bit of time to prepare, if I may.
I'm fine with that, but as long as it's being done in a diligent fashion.
Yes, sir.
And I hold lawyers to that standard all the time. That's what I'm talking about. That's why I'm constantly asking what else needs to be done. I told everyone in this division 6 months before I took it over, we had meetings, I explained these things. This is what I expect. I try not to hold people to some higher standard that I might hold myself to, and did as a criminal defense lawyer for 15 years. But there needs to be progress every time we come to court. And if there's not, we might as well be going backwards, which your case seemingly has been doing. So write down what you want me to address as far as the Nelson inquiry, and we'll have another hearing on it, but everyone has to be on notice as to what it is. All right. Anything else, Mr. Dykes?
When I need to be back in court.
I'm going to put you on December 23rd, but we can certainly address it ahead of time. I'll tell you what's going to happen. When I get the copy of your Nelson paperwork that you want me to look at, I'm probably going to have my assistant call the clerk the same day and say, put it on the next possible date.
Yes, sir.
So the ball's in your court about when you get that to me.
Yes, sir.
All right. Thank you, Mr. Dykes. 12:23, 9 o'clock.
Thank you, sir.
Judge Oberliesen, I don't have any further business if I could be excused.
Yes.
Thank you.
Thank you.
Judge, this is Robert Clyde Harrison. My last conversations with the state attorney, I was trying to negotiate the case down some, and she suggested we go ahead and set the depot of the alleged victim. We've tried to do that and have been unable to get a date from the state where we can do that deposition.
In which case? The battery case?
Yes, sir.
This is over a year old.
Yes, sir.
Why hasn't the depot been set before that?
Judge.
I mean, I understand right now it couldn't be set because you couldn't get a date, but.
Judge, I don't know. I know that we had him evaluated, and we were focusing on trying to get him into a treatment facility. And that was where our focus was.
All right, so what are you asking for, Mr. Williams?
Judge, I'm going to have to ask to continue it, I guess.
Is it just the deposition of the alleged victim?
I believe so, Judge.
And as we just talked about, I'm writing it down, and that's what I'm going to
Yes, sir.
have in my notes next time when we come back. December 23rd, 9 o'clock.
Thank you, Judge.
How many do we have left?
23rd.
Yes, sir.
Mr. Joseph Warren.
Judge, this is the case that we had scheduled for trial. The court ordered a competency eval. I've not seen that, based on things that happened in court. I've not seen that evaluation. I did provide the court with an order some time ago, and I believe the court
I signed the order, right?
I believe so, Judge. There's also a question raised about him hiring private counsel. I've not seen a motion to substitute counsel or notice of appearance from anybody.
All right, have you checked in with Dr. McDonald about it? I signed the order back on September 24th, so over 30 days ago.
Judge, I have not, no, sir.
All right, Mr. Horner, are you thinking about hiring someone else?
I've been working on it, Your Honor. I can only do so much where I'm at.
Oh, I understand. I just,
kinda hard.
I've seen cases, even today, people ask for continuances because they're hire new counsel, and then they don't, and nothing's been done on the case for 2 months or 4 months or whatever it's been, because they're being told they're not going to be the lawyer anymore. So I just want to make sure if that's something you're doing that, because you've got an opportunity to do it.
I've been trying. My people ain't got no money. My mom just got out of the hospital again. Having a
Have you
stroke.
seen Dr. McDonald yet?
No, sir.
What do we want to do, Mr. Williams?
Judge, if his confidence is in question, I can't really do anything.
All right, let's put it on 12/23, but Mr. Williams, I'm asking that you follow up with Dr. McDonald's office. I mean, for all I know, she never got the order, but I signed the order 35 days ago.
I got one of the orders in my pocket. It says something about Escambia County Jail.
Judge, I think she may work out of Escambia.
No, her office is in Fort Walton, I'm pretty sure, at least it was the last I heard.
Maybe I'm thinking of Dr. Zeman then.
Dr. Zeman, I believe, is from there.
I do know that I went to using Dr. Zeman because he was less busy than Dr. McDonald. And that's why I've been using Dr. Zeman for some time.
All right, but if you could follow up on that to make sure she's received that order.
I will.
She's listed on the people who received it, so I'm just not sure what the problem is.
All right, Judge.
All right, thank you, Mr. Horn.
Thank you.
We're going to take a quick 5-minute recess.
Yes, sir.
All rise, please.
Judge, state's going to offer time served on this as constructive possession of firearm. Madam Clerk, is it 515 costs or 525? 515?
Can you turn off that monitor? How does it turn off? Try to control it from here, it's just. It's fine. It's just.
Mr.
I
Horn,
don't think
have
I've
I
ever
ever
seen it
gone
like
over
that
with you
before,
what
and it's been out all day.
your rights are? You know, you got the right to a trial, you got the right to have me question witnesses, force witnesses to come in. Did I ever go over all that
Yes,
with you?
sir.
Okay. All right. All right, if this is what you want to do, then I need to get your signature right here. There you go.
And this was, and we will.
All right, Mr. Horn, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Maurice Horn, Jr., 08-25-92.
All right, and Mr. Horn, you're here in 25 CF 1241, possession of a weapon or ammunition by a convicted felon, which is a third-degree felony, punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to plead no contest as a constructive possession, which means there's no minimum mandatory based on the state's agreement. Your sentence would be adjudication of guilt, so that's a felony conviction. Time served, $515 in court costs, and a $150 PD fee. I can give you 90 days to either pay that or set up a payment plan.
Yes, sir.
Is that what you want to do? All right, have you gone over this agreement with your lawyer? Did you understand and sign it? Are you satisfied with your lawyer's advice? Are you under the influence of any alcohol, drugs, or controlled substances? Any mental health issues that you're currently suffering from? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you plead, there's not going to be a trial, and you're giving up your trial rights, which are on page 2, that agreement that you signed? Do you understand if you're not a U.S. citizen, this could lead to your deportation? All right, and what is your plea to the constructive possession of the weapon by a convicted felon?
No contest.
All right, I'll accept your no contest plea is freely, voluntarily, knowingly given, adjudicate you guilty, time served, $515 court costs, $150 PD fee, give you 90 days to either pay those fees or set up a payment plan with the clerk's office. I need you to be fingerprinted, then you have 30 days to appeal the judgment and sentence. This is a guideline sentence as you scored 39.20 points. Thank you, Mr. Horn. Have a good day. Oh, I thought it was because of it.
Sir Hudson.
Hey, Gary, how you doing? Judge, this is one where I'm double checking, because when I first did up this list, we did not have discovery, but it looks like an exhibit's been filed.
Try to give him a signature.
Give it a look. I want to give us.
gave me this.
Judge, I'm going to have to move to continue Mr. Hudson's case. I think this is the first time.
Is that the DUI case?
Yes.
Would he plead to misdemeanor DUI for time served? It was on the bicycle. I don't know if the statutory requirements apply. I don't know that.
I think if it's a DUI, they do.
Yeah, it's another bicycle one.
Yeah, it's on the bicycle.
Let me,
I wasn't on a bicycle. I wasn't drinking.
yeah, that's the problem we keep running into.
I was on the sidewalk, eating lunch, drinking water.
I don't think you can get around, I don't think you can do time served on a DUI. You could do time served on a reckless. But you might have to talk to somebody else if you're doing a reckless, although it's got no jury appeal.
No, I don't have to talk.
But I don't think you could do time served on a DUI because the statutory requirement.
I'm saying even on the bike, I understand that they suspend driver's license, impound, and all of that. But if it's a bicycle, do they still impose those requirements?
It's a DUI.
Oh, reckless.
All right, you want to plead reckless?
I'll play reckless.
Okay, for time served adjudication?
Yes, sir.
All right. All right.
So I'll get out today.
Yeah, you will on my case. I don't know if you got a signature bond on the
Yeah,
other
yeah.
one.
Yeah, they're all signature
Then
bonds.
yeah,
And
you
this
should.
one is.
Gary, you and I have gone over these things, I don't
Yeah,
know how
yeah.
many times.
Yeah, yes, sir. I got signature
And Judge,
bonds.
just so that you're aware, I did send an email over on this one as well.
Oh,
No, I don't want you to think I'm just waiting until.
Right here?
Yes, sir.
oh, what was the email about?
Oh, it was asking for time served from Mr. Hudson.
Okay. Misdemeanors, I haven't got signature bonds.
Okay, then you should be getting out.
Okay.
Go ahead, Dating that for you.
Wasn't this case supposed to be on Monday?
Excuse me?
Wasn't this case supposed to be on Monday originally until he got arrested on new charges?
It was.
So. We're here 2 days later than we were supposed to be.
Yes, sir. So it's a plea to misdemeanor reckless, statutory maximum on those is 90 days county jail, if I remember right. And he's going to get time served.
What is court costs, is it 300 because it's criminal traffic? 368.
Yeah, I think that includes a $5 to the radio fund, if I remember
I
right.
don't think that matters. All right, Mr. Hudson, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, you're here in 25 CF 1440, charged with felony DUI, which is punishable up to 5 years in prison. Do you understand that?
Yes, sir.
All right, the plea agreement between you and the state is that they've reduced the charge to reckless driving. The agreement between y'all is an adjudication of guilt, time served, and $368 in court costs. Is that what you want to do today?
Yes, Your Honor.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your
Are
Honor.
you satisfied with your lawyer's advice?
Always, yes, Your Honor.
Always. How many prior misdemeanors does he have? It's got to be 24.
I would not venture to guess, Judge.
Just a second, Your Honor, I'm accessing the score sheet.
And I can't see everyone if they're a conviction or not, but it's been a while since I've seen this many.
It is many to count. I have 14 plus 3 plus 31 plus 15 plus 13, and it goes on. A lot. I mean, the prior record only, Your Honor, is 53 points.
So he would have scored on
Oh,
a
yeah.
on a felony.
Yeah, he would have scored.
It's all misdemeanors too.
He would have scored 46 months.
And the state's offered him reckless driving time served. All right, Mr. Hudson, you understand there's not going to be a trial of any kind based on the offer you've been given? And you accepting that offer?
Yes, Your Honor.
And you understand you're giving up all your trial rights?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled
No, Your
substances?
Honor.
You currently suffering from any mental health issues?
No, Your Honor.
You understand by entering this plea, if you're not a U.S. citizen, you could be deported?
Yes, Your Honor.
All right, and what's your plea to the amended charge of reckless driving?
No contest.
All right, I'll accept your no contest plea to the reckless driving, adjudicate you guilty, time served, $368 in court costs. I'll give you 30 days to pay those costs or set up a payment plan.
Thank you, Judge. Okay, Gary.
Don't think I need fingerprints on a reckless.
Oh, on the misdemeanor?
30 days to
Charles.
appeal.
Yeah, but I'm saying with the fines.
The next person, see, I know.
Oh, a payment to clerk's office.
Okay.
Mr. Mark Flavius Jones.
Okay, Mr. Jones. Here's the offer I went over with you. Signature right there. Judge, Mr. Jones advised me, you mind if I date this for you, sir? He's on probation out of Alabama currently, so I'm going to ask that this run concurrent. Do you have any objection?
No.
Wait, what, run concurrent?
It's a offer for probation. I'm going to ask that run concurrent with the probation he's serving in Alabama. He's actually from Alabama. There, I've explained to him he's going to have to go through the whole transfer thing, but since he's already on supervision over there, I suspect it will go relatively smoothly. It is a felony petty theft, so we need a score sheet on it.
I didn't provide you with, I think I did one.
What's he on probation for in Alabama?
Well, Judge, it's a felony petty theft based on priors. I'm going to guess it's probably petty theft. Here we go, I'm sorry.
All right, Mr. Jones, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name, please?
Flavius Cortez, Your Honor.
All right, Mr. Jones, you're here in 25 CF 1582, where you're charged with felony petty theft, which is punished by up to 5 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement calling for you to plead no contest to that felony petty theft. In return, the state has offered you adjudication of guilt, 5 years probation, reserve on restitution for 90 days, $515 court costs, $150 PD fee, 100 hours of community service. Are those going to be done in Alabama?
I would anticipate so, Judge.
No trespass at Alta. Maintain employment or 5 job applications per week. Take an anti-theft class. And any probation, it says, is going to run concurrently with any probation he's currently serving. Not sure we can really run consecutive to another state, but All right, is that what you want to do, Mr. Jones? It's fine, or yes or no? Okay, you can put your hand down. Did you go over this plea and sentencing agreement with your lawyer? Can you pull the microphone closer to him? I can barely hear him.
He's very soft-spoken.
Yeah, I understand, but, this is an important thing. It needs to be done right. Did you sign the agreement?
Yes, sir.
All right, and are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Anyone force you to do this? Anyone promise you anything in return for your plea?
Sir.
You understand there's not going to be a trial, and you're giving up your trial rights which are listed in the agreement that you signed? Say again?
No, sir. You said, did anybody promise me anything?
No, the next question was, do you understand there won't be a trial?
Oh, yes, sir.
And you understand that you're giving up all your trial rights, which are on the first 2 pages of your agreement that you signed?
Yes, sir, I understand.
Do you understand if you're not a U.S. citizen, you could be deported because of this?
Sir.
You understand that this is a felony crime of dishonesty that you're being convicted of?
Yes, sir.
And what is your plea to the felony petty theft?
No contest.
No contest.
Accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 5 years state probation. You can transfer that to Alabama, but you have to go through the Department of Corrections to have that done through the Interstate Compact, reserve restitution for 90 days, $515 court costs, $150 PD fee, 100 hours of community service. Don't trespass at any Ulta store, specifically the Crestview store. Maintain employment or 5 job applications per week. Take an anti-theft class. I believe that's it. So I need you to talk to probation, then be fingerprinted, then you have 30 days to appeal the judgment and sentence. This is a guideline sentence based on the fact that somehow you only score 7.9 points, despite this being on probation. Does the state not score probation violations because they're not here?
That's correct, Your Honor. He's not on probation.
Judge, also, if I remember right, it says before the 4%.
Say again?
Or at least it used to.
What's that?
Score
Does.
For probation, you say before the court for sentencing.
I understand.
How we doing? Just 1 second, Judge. All right, so Judge, I raised an issue with the state involving Miranda, and she's emailed the officers on it. Do you think you might hear something back where we could resolve it on Monday?
We could resolve it on Monday.
Okay. Let's pass it for Monday then, plea or continuance. I don't see a problem in this case. And it looks like we're going to be able to get it resolved on Monday.
All right, Monday, November 3rd for plea or continuance.
Judges, just realized I killed the mic when I was saying that. We're passing it until Monday for your continuance. All right, I'll come out to the jail and I'll go over the Miranda issue with you, okay?
Thank you.
Let's go in.
Coming back Monday, you said?
Yeah. Judge, if I can pass him clear continuance on Monday, you would. So I just need to go over with him what we're doing in terms of her agreeing to forge and what bars to bed means and stuff like that. And looks like he's going to take that, Judge.
Okay.
Okay, all right, I'll probably see you Friday afternoon.
Okay, thank you.
Okay. Yeah.
All right, it's going to be November 3rd, clear continuance.
Judge, I had a conversation with the state attorney earlier today. I'm going to move to continue the case, but it looks like it's going to be not as bad as we thought it was going to be.
Yoni, this isn't your case, right?
No, it's Miss Basso's case. She said she agrees to the continuance.
That's fine. All right, 12:23 at 9 o'clock.
All right, so I'm going to, as soon as I get something firm from her, I'll come out and I'll go over it with you. Don't talk about your case. Okay. Hey, Mr. Lee. Judge, this is another one we tried to coordinate a depot. Also, I had done an authorization to have an evaluation done, and I don't have that back yet.
That internal?
Internal, yes, sir. So if I can move to continue the case?
Hey,
Can I give this
No
to you?
objection.
Yeah, you sure can. You sure can.
December 23rd, 9 o'clock.
Okay, okay. I'll give it to Dave, okay? Yeah. Okay. Judge, this is the first time up on that Leo case. He's got a violation of probation tracking along with it.
919 case? A different one.
I'm thinking that that's the VOP. That's what my notes have. I may be wrong about
I
that.
think, Your Honor, you're correct. I think it's 919, and it's a felony petty theft. It was on probation on that case.
And then he's got that Leo that's 1248.
Yes.
The short version is, Judge, I'm going to move to continue the case. It doesn't look like I'm going to be able to get it resolved this time around. I'm showing it, I've got a note that says first time up.
I understand, I didn't realize the petty theft case was a VOP.
Yes, sir, it is.
The docket that we get now doesn't seem to say that anymore. It used to say that, and now it doesn't.
Yes, sir.
12:23, 9 o'clock.
Thank you, Judge.
What's that? No,
They're not.
It used to say, usually here, it would say VOP conference, but maybe on pretrial conferences it doesn't do that. I'm just thinking of miscellaneous dates or. Well, it's just from May. So it'd be- Who do we have next?
I'll talk to you about it later. We
Okay.
can't do this here.
Yeah, so you're gonna come to the jail and see me?
Yeah.
Yeah, all right.
Okay. Judge, this is one of the cases that we're having some discovery issues on. We filed the demand for discovery, going through it. It didn't say.
I'm sorry.
I'm sorry.
Is this Andrew McDonald?
Yes, sir. He's got one new law violation, then there are two VOPs that are tracking along with it.
Okay. All right, so what's the status of the discovery?
So we've got some information, did not have an offer, did have a score sheet. I don't see any FIBR's report, just the first appearance stuff. We do have body cams and photos and some victim impacts stuff, but I don't have any written statements, any of that material that ordinarily I would use in a depot to prep for the depot and to ask my questions.
Ms. Leone?
I'm reviewing the case, Your Honor. I wasn't on this case from the beginning.
I had sent over some information on it saying that, from the notes, I can see the victim wants to go forward and was upset about the defendant calling her from jail. He scores about 50. This is actually what Ms. Leone told me. I copied Courtney so she can follow up on any additional reports we may have. We sent him what we had on October 8th, but we're still missing substantial materials, at least the last time I checked. I'll pull it up again now.
I showed that we sent, 1 second. In August, we sent discovery, some discovery at least.
Right, that's what I'm talking about is we got, like body cams and we got photos, and we got your witness list. But what I didn't have, and we got first appearance sheet. We got your victim input stuff, but what I don't have is offense reports, arrest reports. What here in Okaloosa is FIBR, is what that stands for, I don't know, but that's what's across the top of it.
I can say that I don't have that either. So I'm not sure if it
You
exists.
don't have their arrest report?
The additional reports is referring to, what I'm just saying, it shows that we have shared everything that I have.
This would be more similar to, in other counties, an offense report.
I understand, but you said that you didn't have the arrest report. That's why I was confused about it.
Well, I have the probable cause statement from the first appearance, but I don't have the more detailed report that has
an offense report.
An offense report.
I'll write a note to the assistant to look into it. I just can state that we shared what we have.
Well, my notes are that you were looking into that when I emailed you before.
Mr. Williams,
just,
this
you can only
wasn't
do
my
what you can
case.
do, I get it.
It has just become my case, so you don't know if you emailed me or not.
My notes say email AL, re-offer and disco done. AL replied. From the notes, I can see that the victim wants to go forward.
If I answered that, it's because of what I read. I'm not. Did you ask me for what was missing in that email?
I don't see any. No, what I would have sent you would have had to do with not having FIBRs, et cetera, just first appearance stuff, body cams and photos are in file. And your response was, from the notes, I can see the victim wants us to go forward and was upset about the defendant calling her from jail. He scores about 50 months with the VOP cases. I've copied Courtney so she can follow up with any additional report we may have.
Yeah.
And then I show that we sent him what we had back on October 8th. But I can't send him what I don't have. So I'm in a position where I need that material in order to proceed forward.
Client seems to want to say something, but I don't want to tell him to because. I
Well,
want him-
he'd done a Nelson previously, Judge.
I remember.
Is there something you wanted to say to the court?
Yes, Your Honor. I feel like this is somewhat of an embarrassment. This fellow still hasn't came to see me. I filed an application pertaining to those issues and issues that I had on other cases before. I'll still try to do some of my own stuff. Like, I'm trying to get help. I know that he has a duty to advocate for me. All this stuff that he's talking about. That
Are you
he's
saying
aware
you
of.
haven't seen him since the Nelson hearing?
No, sir. But
Judge, I'm showing that, I'm not showing where I went out since the Nelson hearing. I'm showing where I
2 months
prepped him
ago, Mr.
for
Williams.
arraignment, although I'm not sure when the Nelson hearing was.
Sir,
Looks like it
Hearing
was.
August 27th.
he told me that day he'd be to see me. You told me, sir, that he only had it a few days during that time. That was one of my complaints in the Nelson hearing.
I'm showing that I went to see him on the 8th, and that we had.
The 8th of what?
Of July. And that I prepped him for the hearing. I advised that I'd filed a motion for his relief because they hadn't filed the release because they haven't filed an information, but that wouldn't help him with the violation of probation. We discussed that he alleged that the victim was not going to be cooperative. Like I said, we do have victim input stuff from her. I've gone out to see him other than that where I've had him scheduled with other people, and when I get to his name on the list, he's already gone back up. When I have met with him, I've had to go out just to see him so that he doesn't have to wait. And I understand he's wheelchair bound and it's an issue for him. But I don't have a note where I've classified it as actually seeing him. Since the 8th.
Of July.
Yes, sir.
So almost 4 months ago.
Yes, sir.
McDonald? What would you like me to do?
I don't know what, I called the Nelson hearing, you denied that.
Well, that was because he hadn't seen you for a month or so, and now it's been closer to 4. So I would consider that to be different.
Yes, sir. I mean, since I've been approved for Phoenix House, I don't know what the state's gonna wanna do with me. I feel like I don't know, I want help. I've been to prison, and prison doesn't have a reintegrating process, sir. I want help. I really want help. I don't mind.
What's the plea offer at this point?
Judge, I don't have an offer. She noted that he scored 50 months.
Can check 1 second.
I do have the score sheet.
He offered his guidelines on.
What do we want to do with it?
Well, Judge, I need to get these materials. I don't want to set depositions without having the offense report.
All right, then file a motion to compel then, Mr. Williams.
I will, Judge.
I think I've brought this up several times myself, not in Mr. McDonald's case, but I don't think I've dealt with one Richardson hearing, one Brady hearing in the 10 months I've been here, yet every time we're in court, all I hear about from every defense lawyer is we're waiting on stuff. File the motion. I mean, I can't do anything else if no motion's filed.
Judge, I think we all try to be understanding of the issues that they deal with, and so we try not to do that. I did draft one up in another case.
Well, I understand, Mr. Williams, but when he says you haven't seen him and you agreed for 3 to 4 months and you don't have discovery, what other better time is there to file something like a motion to compel?
Yes, sir.
Oftentimes, my experience, both on the bench and before, is it's often the agency and not the officer who wrote the report, but that just hasn't been sent over to the state attorney's office. And a motion to compel, and an order to compel, with a judge's signature on it, typically gets things moving. I think it has to be, there has to be a discussion as far as, professionalism and courtesy that say, hey, I'm not trying to blame you for this, Mr. or Mrs. State Attorney, but I need what I need to represent my client. So please do what you can do to get it over to me. And I know they're short-staffed, but I don't think that gets very far with people who are sitting in jail not being seen by their lawyers.
Well, and Judge, that's what I used to do, and that's what my secretary then took over, I think probably because they felt like I was being too difficult. All right, Judge. I'll file a motion to compel on.
I'm not telling you that's what you should do in any particular case, but I just don't know what else we should do. I mean, we shouldn't be coming to a second and third pretrial conference and still talking about we don't have offense reports.
Well, Judge, I don't.
All right, so what are we going to do today? All right, I'll make the decision. We're going to put it on Monday the 3rd, and y'all are going to update me on what's been turned over since.
Yes, sir.
So, Monday, November 3rd for status of discovery.
Yes, sir.
As soon as I can get you back, other than tomorrow, and since it's after 5 o'clock already, I don't think much is going to happen before then, Mr. McDonald. So I want to get the ball rolling for your case. Not just you, but everybody. Their cases should be moved. And I know everyone's issues with staffing right now, but, the Constitution doesn't take a back seat to personnel issues.
Yes, sir, I understand. Can I ask the court a question? When I was in here for the Nelson hearing, I had another one in on Charles Hall, who's part of the public defenders, where he was conflict law firm case. If I have a conflict in that law firm.
Well, it's not a law firm, it's.
The public defender's office, rather, I apologize.
Judge, I would agree. I've not been notified of a conflict that he had.
I wrote this fellow several letters, actually. And I haven't got a response.
Normally, what happens
It usually depends on what the conflict is. Sometimes the conflict's because of the other person, not because of what they know about you. And they keep that case instead of yours. I don't know. I mean, I can try to come up with hypotheticals in which that is just fine, but I don't know the facts of it. So if there's a concern, you can certainly raise that.
Judge, my secretary, Mr. Hall, or Mr. Russell, is actually the supervisor that would make the decision on a conflict. And this is the first time I'm hearing of it.
Is it a 2023 misdemeanor?
It's a misdemeanor, sir, yes, sir.
Well, but when's it from?
I believe it's 2025.
I don't see any cases, any misdemeanor cases that came up during 2025. All right, y'all can take a look at it, but
I'll take a
I can't investigate it right now. If they determine there's a conflict, if you think there is a conflict and they say there isn't, then you can certainly bring it to my attention. I don't normally get too involved when lawyers say there is or isn't a conflict, because sometimes it forces me to know things about privileged communications that you have with your lawyer or that their other clients have with them. But if it's a conflict, it's a conflict, and they can file that, and I'll appoint you the regional office of conflict counsel if it's a conflict. But I'm not sure what you're referencing, because the most recent misdemeanor case is from 2023 that I can see. Maybe I'm missing it.
I believe you must be missing it. I believe it's 2025.
No, I'm sorry, 25 CT 847.
Not coming up under his name when I clicked on it. So I've got everything else. Well, at least I've got quite a bit to look at when I pull up your name, but 847?
Yes, you're on 847.
I don't know. I'm not sure what we're going to be able to resolve for that today, but if y'all could look into that, Mr. Williams, to see if y'all
I
have
will, Judge.
some sort of conflict.
I'm not sure Mr. Kleins represents him on that one.
25 CT 847?
Yes, that's what I have.
Our first snafu with the new system.
And there
Not
was a
coming up,
motion
I'm
for
typing the
Nelson
number
hearing.
in.
Yeah, on September 2nd.
Yeah, we're considered a firm for conflict purposes. The thing is that the way that actually happens.
That was pursuant to a Nelson hearing. You know that, right, Mr. McDonald? So it wasn't that they didn't admit there was a conflict, did they? You filed a Nelson inquiry against Mr. Hall, correct?
Yes, sir.
Okay.
It's a conflict, right, within that firm.
Not necessarily. I don't know what the conflict was, like I said.
Same one that I'm dealing with now. Last time I had this conflict, I was financially able and hired more than others. I'm not financially able now.
All right, we're going to see your case on Monday. I'm not trying to stop you, Mr. McDonald, but I want to hear all about what you have to tell me, but I can't delve into other cases because I don't know the facts, and no one seems to want to tell me candidly what's going on here.
Thank you, sir.
All right, but I want to know what's going on with discovery between now and Monday, because this is not, we should not be at a second pretrial and be talking about offense reports. And again, if a state doesn't have them, they need to go to the arresting agency and say, where is it? And I can tell you, this is not a new phenomenon, Mr. McDonald. When I practiced criminal defense, I was always trying to track down things before I went to depositions, which is what Mr. Williams is trying to do. So when you show up at a deposition and then suddenly there's a bunch of reports you've never seen, and most of the time the state attorney's never seen, it kind of ruins the deposition, and you have to reschedule it, and it just delays things even further. So I want to know what's changed between now and Monday, and we'll see you back then. All right, thank you, Mr. McDonald.
All right, Judge, I'm going to move to continue the case. I think this is the second time up.
All right. What else needs to be done? Have y'all done depots yet?
Judge, we were hoping to resolve it with a plea. We got an offer on it, but it's not one that Mr. McDonald is going to accept, so we're going to have to potentially try to control.
Okay. All right, Mr. McDonald, we'll see you back December 23rd, 9 o'clock.
Yes, sir.
Thank you, sir. Judge, this is Martin McDonald, 25 CF 1732. He's got a bond hearing set for tomorrow. My notes, we had a couple of cases that we put them on the docket because we couldn't find the next court date on the clerk's computer. And this might be one of them. He might not have been arraigned yet. We do have an info that was filed, looks like back on September 25th, and no discovery as yet. Although with it being filed 9/25, they're late, but they're not. Does the court maybe want to deal with it tomorrow?
You had an arraignment on September 25th.
We sent the initial discovery on the 25th of September.
All right, then he has been arraigned. I've filed a bond motion that's set for a hearing tomorrow.
We'll deal with that tomorrow.
Let's see, and
I mean, it's a bond
I'm
reduction.
showing-
He's got a $2,500 cash or professional bond.
I'm showing emails sent 10/28, 10/20, and that would be from my secretary. Like I said, she kind of took that over after a while. I was doing them. Ma'am, he is inquiring. Do you have an offer for today?
I got 80 days in.
Is that at Walmart?
Yes, ma'am.
Yes, ma'am. I'm looking at your information. Or Josh's information.
Yeah.
I don't have a score sheet.
The score sheet, he scores, that I can tell you, minimum of the points, 118 points. That's equal, I can read, I have to open this, hold on. Equals to 67.5 months as charged.
Now the score sheet's got to be wrong because remember we talked about this?
Mm-hmm.
On the two charges that we were talking about, that wasn't me.
Right.
On the armed burglaries or armed robberies, I had nothing to do
Well,
with that.
they haven't formally sent me a copy of it, so I'm not in a position to go over it with you.
I understand that.
As yet.
It's totally incorrect.
Judge, do you set it for status on Monday?
And
Or
if,
do you-
if it's a case, I can review the score sheet. I didn't prepare the score sheet, so I have no
All right.
idea.
November 3rd, 9 o'clock for status on discovery. We have a bond hearing tomorrow, so if anything changes between now and tomorrow, I don't expect it, but we can address it.
Thank you, Judge. All right, so I'll see you tomorrow morning on the bond thing. Maybe we'll have more information then, or at least be able to get you out of jail.
I
Okay?
appreciate it.
Okay. Judge, my understanding is that Mr. McDonald filed a motion to be indigent for costs.
Yes.
The clerk took that as a motion to have us reappointed to you.
No,
You're just wanting to be able to incur costs.
yes.
Okay. Judge, with that, I'm going to orally move to withdraw. That kind of what we thought was going on.
I had no idea. I just saw you were appointed. I figured Mr. McDonald wanted a lawyer.
No, I did not.
No, you know how when you,
I understand. I just, right, Mr. McDonald.
And that's why I haven't filed a notice of appearances yet, Judge.
Mr. McDonald, you're here on, let me cross off Mr. Williams. 24 CF 1950, 24 CF 2917, 25 CF 713.
Yes, sir.
What would you like to do, Mr. McDonald?
Well, I thought that we were scheduled for depositions on the 7th.
You were appointed a lawyer before then, that's the problem.
I didn't ask, I didn't.
Oh, I understand. I'm just telling you what the problem was.
Okay.
I'm not saying it's an excuse, but it is the reason.
Okay.
So-
I'm sorry, Your Honor, I didn't mean, I'm sorry that the court misinterpreted that. It was not my.
Well, hold on. I didn't misinterpret anything. The clerk's office, for some reason, assigns you a lawyer despite the fact that you never asked for one. But then it goes on every docket and every piece of paper regarding your case that you're represented. Obviously, that's not what you wanted,
No.
now that you're telling me that.
Right.
So what can we do to fix the situation now, Mr. McDonald?
Well, I was hoping that we would reschedule the depositions.
Do you have the list of the people you wanted
Yes.
to depose? Have you filed that list?
We filed that in August, wasn't it, Ms. Leon?
I remember at one point you told me who you wanted, and I had a written list.
Yes, yeah, we went over a written list and everything like that.
But have you ever filed anything with a list of people you want to depose? Just so I can track it down and make sure everyone's got the right people.
I didn't file it in that manner, no, sir, I did not. Well, we went over it in court twice. We done the list twice in here, and you wrote down and you said that your office was gonna handle that situation and get those things out to those people, and then we had set deposition scheduled for the October.
What I think I need you to do is you're going to have to fill out subpoenas for who you want, and then we can make sure they get served. But I got to make sure you give me all the names and their addresses. It's not for me to track them down.
Okay, I can do that, Your Honor. I didn't bring that with me today.
That's fine, because obviously we're going to have to coordinate these things.
And I'll just send
Again,
that to
because
your office.
I know the coordination went on for some time because of all the moving parts. But, yeah. Are you trying to do witnesses in every one of your cases?
No, just the 2917 case was first originally planned.
Okay. Do y'all have subpoena forms for pro se people? Okay.
I know.
All right, Mr. McDonald, I'll inquire into the clerk's office tomorrow to see if they've got those forms they can give you so you can fill them out and have them sent back for service.
Yes.
But obviously, you kind of have to be, I don't know if this is a term y'all use, Johnny on the spot with those. As soon as you get them, turn them
Do 'em
around,
right
get
then,
them
yes,
back.
sir.
That way we can get a date that's not 3 months off, because that's the problem. And I'm not trying, I think I said this before to you, and I want to make sure I say it again. I'm not trying to encourage you to get a lawyer or have a public defender appointed to you, like was seemingly done without your consent. But they just have the personnel to turn those things around quickly and get it done, the know-how, and because they do it literally every day, you're going to have to send those back as quickly as possible so they can get served. Because this is not normally something the court involves itself in. I was trying to make it a little bit more expedient, and then
We'll do that very promptly,
unfortunately,
sir.
someone threw a monkey wrench into our gears here. All right. But if you can get that list, together, and then I'll see what I can do about getting subpoena forms sent out to you so you can fill them out, send them back in for purposes of service.
I'll do that
Because
tonight.
you're indigent,
Yes.
and we know that because you filed for that again.
Yes, I did.
Then they should be served at no cost to you, but we just got to have the subpoenas prepared.
Okay.
Okay.
That's why I did that, and so, and I will do that list tonight, and I'll have it in the mail.
Okay, I appreciate it.
Just 1 second.
Yeah.
He had requested some discovery for the case 24 CF 2917. He requested the COD report, and I have him here for him. So I just need him to sign that he received it.
Okay. Thank you.
That's yours, and you can sign here, please, if you got it. 10 pages.
All right, thank you.
Anything else you were looking for, Mr. McDonald?
Not today, since we got set behind, I think we just need to continue and get this really done.
That's it.
Well, we'll put you on that 12/23 date and see how quickly we can get another date. But
Okay.
I want to make sure you've got all the subpoenas maybe ready to go, and all you got to do is, put the dates and all that on there, and then we'll go from there. Is there anything else that filed that we need to address today?
I did file a motion to severance.
Severance.
Yes,
Sever
the
what?
accounts. Because
We're probably going to have to hear that on a separate day,
Okay.
Mr. McDonald. That's fine, I just want to make, hold on, why I'm asking is I want to make sure that we set that for a hearing.
Okay.
And you filed a motion for severance?
Yes, sir, I did.
And is that in the 2917 case?
Yes, I did.
Ms. Leone, any issue with setting that maybe for the December 4th date?
No, I don't have an issue. I don't think I've seen it. I do open all the,
When did you file it, you think, Mr. McDonald?
I filed it, can you give me a moment? Yes, I'm sorry, I got the phone around.
The problem, oh, here it is. It actually says motion for severance.
it does. I missed
It was filed, I've got it as October 20th. Docket line is 223.
I'm fine to set it for that time, at that time, Your Honor.
This is what we're going to do, Mr. McDonald. My next miscellaneous date, well, I've got one next week, but it's a little soon. But the one after that, because this is my trial period coming up, is not till December 4th. So we'll put you on December 4th.
Okay.
Yeah, let's just put it for 2 o'clock.
Okay.
For your motion to sever to be heard. In the meantime, I'm going to see what I can do to track down if there's a subpoena form that we can get sent over, a stack of them to you, so you can get those prepared, and we'll work on that date.
Okay, I'm going to do that tonight, and I'll have it in the mail tonight.
All right, I appreciate it, Mr. McDonald. Have a good night. Thank you.
Judge, I'm sorry, you
Go ahead.
ready for me? This is Desmond McTier. Mr. McTier has filed a request for a Nelson hearing with some peculiar allegations.
I hadn't seen it. I feel like I'm not getting pro se or jail inmate filings like I used to.
I think I have a copy that I can provide the court.
Let's see. Oh, I may have seen this one. Let me check that. Let's see, represents. Oh. I do remember reading this now.
Now, Judge, just to let you know, I attempted to have internal evaluation done on Mr. McTier. He refused to speak to the document.
Okay.
You told me don't speak with nobody there.
I understand. Nobody's mad at you.
All right, so what are you looking for here, Mr. McTier? Are you
fellas,
asking
sir,
for
man.
me to replace your lawyer?
Yeah, sir, I've been in jail 5 months, sir. I got kids, I got family, I got people that like really depending on me out there, like, and this is false allegations on me, like that I see in my own case, and I have yet to see this man in 5 months since I've been in this county. I haven't got my deposition. I done asked for discoveries. I done asked for a bond. Sir, I've been resident in Okaloosa County all my life. You know, sir, I don't have no.
We're not here for a bond motion, Mr.
Yes,
McTier.
but we're here to evaluate this. I have not seen this man nothing but one time in this county. Like, sir, I've been in here 5 months, sir. My son is playing football. My son wants to see me at his game. Like, I would rather just, like, I've been asking him to put motion in for a bond, put motion in for, let me see my discovery. Let me see what y'all got, what's going on. I have yet to see anything, nothing but jail. And sir, it's really working with me now, sir. Cause this is not me. All these false allegations is not me, sir. That's not me, sir. And I'm like now at the point of where I'm just tired of sitting in jail. That like y'all got me hindered in jail to catch a charge that y'all know y'all can pin on me. Like, cause this is not gonna stick. I'm going all the way to the door with it. But it's like it's not. Now I'm just been sitting in here with no talk, no conversation, no discovery, no nothing but a arrest report from him.
Okay, can I now address something, Mr. McTier?
Yes, sir.
Mr. Williams, have you seen Mr. McTier?
I have.
When?
Oh, let me see. I went out to see him initially based on that initial discussion with him. I sought to have him evaluated. And
Wasn't there when that person came.
no, I wouldn't have been there when the
thought it was-
psychologist.
I thought it was a whole like other type of person coming and trying to interfere with your case. Like you told me, don't speak with nobody other than if you're there. So I was expecting for you, my lawyer, to be there, present with this evaluation person, to tell me to accept this valuation. So you never was there. So I was, and like I have paid lawyers every time I
So,
come up.
Mr. McTier, are you objecting to meeting with this person now that you know
I
who
wasn't
it is?
rejecting. I was asking him who he
Mr.
was.
McTier, listen to the question. The question is, do you object to seeing that person now that you know who it is?
I will see him now. I would love. I wrote him back. Asked him about the request.
I
I wrote him
I
back
understand.
and asked him to see him. The
Mr.
dude that in yellow
McTier,
piece of
I want to make sure you understand. I don't read the correspondence you
Oh,
send to
okay,
your
so-
lawyer.
Yeah.
Not only do I not have
writing
access
this
to it,
man-
it'd be completely unethical and unprofessional for me to do that because
Yes,
you have a
sir.
privileged conversation with your lawyer.
Yeah, that's
I-
what I'm,
so-
I've been writing him. Hey, this is just getting old.
All right,
sir.
so what do we want to do today?
Judge, let's do this. Let me pass him and or continue him, and I'll tell Dr. Zeman again to go out and see him again.
What about his discovery?
Judge, I'll have Ms. Wilson send him a copy of his discovery.
He doesn't have discovery yet.
And I haven't got
We don't-
nothing yet.
Mr. McTier, can I talk to Mr. Williams for a second?
Usually, she will go ahead and send it out when she gets a request for it. She doesn't send it out to everybody, largely because of issues with folks leaving their discovery around and other inmates seeing it and jumping on the case.
The PD clients know they have to make a specific request to your office to get it?
When they ask me, I always tell them, just send a request in, my secretary will do
That's
that.
not an answer to the question either.
I'm not aware,
Because if your clients don't know they have to make a specific request to you to send it, and they don't make that request, and I'm not saying you personally, because it sounds like that's kind of a PD's office policy of not sending it unless it's asked for, because I've heard it before from other people. But if they don't know to ask for it, and we show up in court 5 months in, and they're saying, I've never seen it,
we have a stock letter that goes out, and I'm looking for that because I don't recall if it mentions that. Typically, unless it comes up in the conversation, I don't say anything about it. I'm not aware of a policy whereby they're told, every single one is told that, Judge.
when did the doctor go to see him?
Judge,
Ballpark.
2 months ago,
2 months ago?
2 or 3 months ago. Yes. That now. 2 or 3 months ago.
I know that I requested it right after I saw him the first time.
Have you seen him since?
Not since then, Judge. No, I haven't.
No, sir.
I mean, what are we doing? I mean,
Judge, I've
did
had-
he said, is the letter that he sent you in your file there? He said a letter said, I didn't know who this guy was, and
Not that I've seen, Judge, but that doesn't mean that he didn't send it. The, I've got where I sent him a letter. He had asked me to call his dad. I tried to call his dad, but couldn't get through. I'd
I never asked
already.
you to call my dad. I don't even got my dad.
Mr. McTier, please, let him tell me what
No,
he
wait a
wants
minute,
to
I'm
tell
looking
me.
at the wrong, oh, am I? Hang on.
I don't even got my dad.
Hang on, hang on a second, look and see if, no, I'm looking at somebody else's notes.
Life is at hand right now, sir. My kid plays football. He's a straight A student. He's home. This is nonsense.
Well, I certainly, he was on my list of people to see for today, but once I got the Nelson inquiry, I did not try to see him.
Mr. McTier, what are you asking for as your Nelson inquiry?
I don't feel as if this man is representing me in the best of my ability right now, sir. I feel as if
I'm
somebody.
going to remove the public defender's office and appoint the regional office of conflict counsel to you. That'll be Scott Klein's. We'll try to, I'm not sure if he's here tomorrow or not, but we'll try to pass along that message so he knows to come to talk to you as soon as possible.
Thank you, thank you, thank you. With all due respect, thank you, sir.
All right. Do we know if Mr. Klein's is here tomorrow? Take a quick look. Hold on just a second, Mr. McTier. Looks like he is. Let's put Mr. McTier on the docket for tomorrow. And I'm going to see if I can get you set up with talking to Mr. Klein's tomorrow.
Thank you, Your Honor.
You're
Thank
welcome.
you, sir.
All right.
I will bless that, sir. Everybody, I will bless that. Even you,
I know that's a late add-on, but,
God bless you, sir. God bless you.
all right.
God bless you.
All right, who else do we have? More?
We have Moore and then Lehman, they're both pleas.
We got Moore and Morris, right?
No, Morris is not mine, Judge. RCC was appointed on that.
I think I just did that, didn't I?
I had his leases.
Well,
But
is he back
when I
there?
pulled it up, I saw that
Tyshawn
RCC was
Morris?
appointed.
Okay. All right, Mr. Moore, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You state your full name and date of birth, please?
Moore, 020991.
Is misdemeanor stalking a first degree? Misdemeanor?
It is, Judge.
Okay. All right, Mr. Moore, you're here in 24 CF 2046, charged with aggravated stalking, which is a third-degree felony punishable by up to 5 years in state prison. You understand that? All right, I've been handed a plea and sentencing agreement where the state has offered to have you plead to a misdemeanor stalking offense in return to be an adjudication of guilt, 11 months, 29 days probation. You'll have to complete the batter's intervention program, a substance abuse evaluation, any recommended treatment, or the Emerald Coast Life Center. Comply with them. 24 hours of community service, or you can buy that out by making a donation to a domestic violence-based organization or charity. Misdemeanor court costs on stalking, is that different? All right, let me get you that number, and then as far as the your public defender fees, it'd be $50 application and a $50 cost of defense, and it'd be an adjudication of guilt. I think I said that already. Is that what you want to do today?
Yes, sir.
All right, is that the state's offer?
It is, Your Honor.
Okay, and Mr. Moore, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes,
Did you sign it? All right, and are you satisfied with your lawyer's advice and representation? Are you, okay. Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for your plea? You understand that by entering a plea, there won't be a trial of any kind? Do you understand you're giving up your trial rights, which start on the bottom of page 1 and go on to page 2 of that agreement you signed? And you understand you're waiving any potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, and what is your plea to the misdemeanor stalking? All right, I'm going to accept your no contest plea to the misdemeanor stalking charge. Do we have a statute number for that? It'll be adjudication of guilt, 11 months, 29 days probation, complete the batter's intervention program, substance abuse evaluation, any recommended treatment, or comply with the ECLC program. That's one or the other, Mr. Moore. I'm sure you know that. 24 hours community service work, or buy that out by making donation to a domestic violence-based organization or charity. $50 application fee, $50 cost of defense, and court costs.
Yes, the same statute number is going to be a different subsection as the original one charged.
You say
784-048, and then,
I used to read this
subsection
definition
2.
every day in injunction court. All right, so then it's going to be paragraph 2, 784-048, paragraph 2.
Yes.
And 622 in court costs. All right, Mr. Moore, I need you to speak with probation, and you need to be, no, does it need to be fingerprinted on a misdemeanor stalking? I don't think so. Is it enhanceable?
It's
I think
not,
it is,
Judge.
actually is, you're right.
Is it now?
Let me see.
I haven't done.
All right, I'll have you have 30 days to appeal, Mr. Moore, talk to probation. I'm going to make sure if I need that. I see it as part of that statute. I mean, I'm trying to skim through it quickly. It can be aggravated if there's a credible threat. It can be aggravated because of an injunction. Aggravated because of the age of the victim. I don't see it. All right. Your name, sir?
Tasha Morris.
Mr. Morris, I think I just appointed you the Regional Office of Conflict Counsel. I think I signed the order. I want to say it was yesterday or the day before. I'm looking at the wrong date. Excuse me for a second. Yeah, I just signed it. Well, it looks like it was processed today. I signed it yesterday. Oh, no, because they got off of the case, too. What happens, you had the public defender. They had a conflict. It went to the Regional Office of Conflict Counsel. They had a conflict. Yesterday, I signed an order appointing you Charles Williams, who's a private lawyer who takes appointed cases. But he probably didn't know about that because it wasn't processed until this morning, even though I signed it yesterday, because I signed about 100 of these yesterday.
Yes, sir.
Let's see here. Why don't we put Mr. Morris on tomorrow at 9 o'clock as well, because Charles Williams, your lawyer, will be here for a different case. I'll see if I can get him to link up with you.
Yes, sir.
Kind of catch up to speed a little bit, because we've had to appoint you lawyer after lawyer to get someone without a conflict.
Yes, sir.
All right, so we'll see you back tomorrow at 9 o'clock.
Okay, thank you.
I'm not saying he can spend, an hour with you tomorrow, but I'm going to do my best to get him in the same room with you at least. All right, thank you, Mr. Morris. We'll see you tomorrow.
Mr. Williams, did you see the email I sent you?
Is it,
You got the discovery for Mr. McDonald.
oh, is that?
Yeah,
Yeah.
so you don't have to file the motion to
And we've
come
got Miss
back.
Lehman for the third time. And that should be it. Is her plea for probation? Layman?
I'm sorry, Your Honor. what-
Layman
Oh, yeah. I
is
think so.
probation?
It is.
Okay. I was gonna try to tell you to go. You've got one more.
Education of guilt, 2 years probation, comply with ECLC, 515 cost, $150 public defender fee. What you want to do?
Yes, sir. Is that correct for all time served? For this?
It would be if you were going to jail.
Okay,
You're not
okay,
going
okay.
to jail, you're on probation. So if you violate probation and go to jail, then you'll get credit for the time.
Okay, okay.
Yes, sir. You mind if I date that for you?
All right, thank you, sir. All right, Miss, is it Lehman? You raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Kimberly Lynn Lehman, November 11, 1986.
All right. Ms. Lehman, you're here in 25 CF 1681, charged with introduction of contraband. Do you understand that? It's a third-degree felony. All right. I've been handed a plea and sentencing agreement that would have you enter a plea to that third-degree felony, which is punishable up to 5 years in state prison. But your agreed-upon sentence with the state would be an adjudication of guilt, so it's a felony conviction, 2 years probation, comply with the Emerald Coast Life Center, 515 court costs, $150 PD fee. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right. Did you go over this plea and sentencing agreement with your lawyer? Did you understand and sign it? Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Currently suffering from any mental health issues? All right. Anyone force, pressure, or threaten you to do this? Anyone promise you anything in return for your plea? You understand there won't be a trial of any kind if you enter a plea? You understand you're giving up those trial rights, which are on page 2 of the agreement you signed? And do you understand that you're waiving any potential defenses you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, what is your plea to the introduction of contraband third-degree felony? I'll accept your no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty, 2 years probation, comply with the ECLC program, 515 court costs, $150 PD fee. I'm going to waive costs of supervision due to the fact that you're represented by the Public Defender's Office and been declared to be indigent. This is a guideline sentence. You scored 29 points. I need you to speak with probation, and then I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge.
All right, thank you, Ms. Lehman. All right, is that everybody back there, sir? Ooh, I'm always worried when it's on 2 different pieces, like that bottom one hits, and the top one keeps going.
Oh.
Hit you on it.
Well, I haven't been out to see